Now, my lord, in this matter, argument is over. Only another 5 to 10 minutes reply is pending. So, and that matter is not marked part heard, my lord. So, my lord, if your lordship kindly fixes this matter any other date, my lord, any date.
Date is the problem.
After vacation,
My lord, then
If you want date, then it will go not even after, you will get in the December.
my lord, it will take not more than 10 minutes.
I
My
was
reply is also almost complete. I'll just show one or two judgments. That's it, my lord. I'll distinguish two judgments. That's it.
Correct. You will distinguish, but my diary should
now
come.
it seems it's better not to get it fixed and rather let it appear in usual course.
Then you will get.
Any day, my lord. Any day for 10 minutes. At 4:15. At any day at 4:15, my lord.
Before vacation, nahi kuch. Then you will get after vacation.
Well, then kindly mark it part heard, my lord, because this matter is completely and exhaustively heard by your lordship, my lord.
If it's so, then you can take the special assignment. There will be no problem.
My lord, only marking it part heard will save me that.
I am not giving any part heard. You know what is the implication in the part heads.
Then, my lord, kindly any date, my lord, 4:15, my lord. I'll not take more than 10 minutes.
You will not take, the other side will be there.
My lord, it's a reply, my lord. I'm giving reply. I'm just distinguishing two judgments, my lord.
बीच में कोई 345 कुछ नहीं है. Actually, problem is appellate side has also come, so I have to adjust one day for the appellate side. That is the only problem.
My lord, I'll not take more than 10
I know,
minutes,
but my diary is not all. कोई नहीं है ना? Okay, remain in the list. We'll see to that. Let the matter remain in the list.
Tomorrow, my lord, is it possible?
It
my lord,
remain
my
in
own
the list. I cannot give the time. Time I can't. Already all matters are fixed on time.
My lord, kindly one order for marking it part heard,
what?
my lord, part heard, my lord. Otherwise, the whole exercise will. If your lordship's determination changes, my lord, then we'll be in. The whole exercise will start.
But you persons know whether the
No, my lord,
That's the fear.
My lord, that's a
That's
fear,
the fear.
apprehension, my lord. And after vacations, usually determinations changes.
So now 20 days is here. Let me see. Let it be in the list. Let it be in the list.
My lord.
My lord, I was, my lord, seeking liberty to mention item number 4 specially fixed at 3 p.m. My lord, we know, my lord, because of, my lord, the bar's resolution today, my lord, and he's an outstation witness, so we have asked him not to come today. My lord, this can, my lord, stand over after the vacation any day, my lord.
Though the matter is fixed today, especially fixed today as 3 p.m. for witness action, but the matter could not be taken up for hearing due to some unavoidable circumstances, and as such the case is adjourned. Let the matter appear on, give the date.
I'll take it, my lord, whatever it is, I'll take it.
22nd December at 2020 at 2 p.m.
Grateful, my lord.
Inform the other side.
Yes, my lord. I'm mentioning upon notice, I'll inform them again.
The plaintiff is directed to inform the other side with regard to the date. Yes, next.
My lord, grant to leave a certified copy of the order dated 20 June 2025 and 12th June 2025.
Why you are waiting for the 2 months? Give. You are the advocate on record?
No, my lord.
Then how you will get?
Matter is disposed of already.
Dispose of. Give. Yes, next.
Item number 1.
Your Lordship, this is the plaintiff's application regarding that notice to produce documents for the cross-examination that is ongoing. I'm being led by Mr. Bose.
My lord, I have to, my lord, I sought for instructions. We have yet not received, my lord, the documents. Whether I would get it or not, I am not sure. But, my lord, I was, my lord, drawing my lord's attention to the provision once, my lord, order 11 once. I possibly have to file an affidavit and it has to come from an officer of the, my lord, bank. That's, my lord, my understanding of the provision. My lord, kindly takes order 11, my lord, as amended.
Correct.
My lord, it says, my lord, this is order 11, my lord, rule 5.
You are for the defendant?
Yes, I am for the defendant. My lord, rule 5, lordship says, any party to a proceeding may seek or the court may order at any time during the pendency of any suit production by any party or person of such documents in possession or power of such party or person relating to any matter in question in such suit. Then, my lord, next is notice to produce such document shall be issued in the form provided in form number 7 in Appendix C to the Code of Civil Procedure.
Correct.
Third is any party or person to whom such notice to produce is issued shall be given not less than 7 days and not more than 15 days to produce such document or to answer to their inability to produce the document. My lord, this, my lord, provision to answer to the inability, my lord, from the bar, my lord, it's not for an advocate, my lord, to answer it. My lord,
That's
officer
why
has to, my lord,
produce.
either or I have to, my lord, explain why I cannot produce. So, my lord, gives me 7 days time to, my lord,
that will be taken as presumption at the time.
adverse inference presumption can be taken, my lord.
Correct.
My lord, I wish my lord, seek, my lord, 7 days time, my lord, to put in this affidavit, and I also raise an issue of maintainability of this application only for the reason lordship takes, my lord, page 9 of the application once.
Yes.
My lord, kindly sees, my lord, the notice to produce which is, my lord, issued. It's under Order 11, Rule 16. This is a commercial dispute. The notice to produce has to be issued in the particular form which is provided in Order 11, Rule 5, Sub Rule 2. It has to be in Form 7, Appendix C. So, my lord, keeping the point of maintainability open, kindly permits me 7 days time to put in an affidavit. I will, my lord, try and explain the conduct of the, my lord, defendant.
Your Lordship, I just like to also state that the notice to produce that is being referenced, it was issued on the 15th of July. Subsequently, on the 23rd of July, they had also said that they would produce.
Affidavit, they are not.
Your Lordship, then tomorrow and day after, where the cross-examination fixed, that cannot go forward. The cross-examination of the defendant's witness. Those dates will also.
Unless there are other issues to be covered, and if it is only this issue which is, my lord, remaining, then, my lord, it cannot go on. But if there are other issues, then of course it can.
No,
I have asked my witness to come also. He is also an outstation.
This document, you can proceed with that.
Your Lordship, I have instructions that my learned senior will not be able to continue with the cross-examination without these documents.
Then you file an affidavit tomorrow.
Tomorrow bank,
because so many time you have taken, you're not produced. At the last moment, you're telling that you file an affidavit and matter is fixed tomorrow. Day after tomorrow, 2 days, the matter is fixed and it's a old matter.
My lord, one day, my lord, it won't be possible. My lord,
What can be done? Let your client face the consequences.
My lord, the consequence
Because
adverse
you
would
have
be
taken 3
adverse.
dates.
I have taken, my lord, I thought that, my lord, I would be bringing the documents. If it is there, my lord, that would have saved time. My concern was also, my lord, the date fixed for cross-examination.
Correct.
I did not want to delay the process.
So if you're not able to, you either you tell that you will not able, then you file an affidavit. That is different thing. Let the proceeding continue.
I have asked my witness to come. The proceeding can continue, my lord.
If you're telling that he will not produce the document and you file the affidavit, I will record your submission. You file the affidavit. Subsequently, let the.
My lord, I am not saying I will not produce the document. I am saying the bank will, my lord, in the affidavit say, my lord, if they have it, my lord, if they get it, they will produce.
Tomorrow the witness can let us see. I will not allow that. Let them. It is submitted.
Or let this application also come tomorrow along with that, my lord.
Already I already directed you. Tomorrow I dispose of this along with the witness examine. You come ready. Either you produce the document or you file an affidavit, or I will continue. I will record that you, in spite of giving so much time, you are not able to produce the document. Then the adverse inference will be taken again.
Whatever inference, my lord, if my lord, any inference can be drawn because of that will be taken. That I know.
3 days you have taken time. The court has liberally given the time. Now at the last moment you are taking 1 month time, 1 week time, and tomorrow the matter is fixed for evidence. So it is a waste of the time. It is learned counsel for the defendant. You are for the defendant.
But I'll file it in 1 day's time then. I'll try and, my lord, have it affirmed by tomorrow.
It is fine that the matter is fixed tomorrow for witness action. Let the matter appear tomorrow. Come ready for crossing.
Well, that direction, my lord, to put in an affidavit.
You file it. I will take that.
Item number 3.
I am the award holder. If Lordship takes the last order, dated August 19, 2025, Lordship will find there was a direction on the judgment debtors to file an affidavit under Form 16A that has not been filed, and
yes,
And in respect of second paragraph, my lord, to take steps, my lord, we have prepared an application that has gone for approval. If it as soon as approval comes, my lord, I will file it.
Yes. Who is for the judgment debtor?
No one is here, my lord, today.
Counsel for the decree holder draw the attention of this court. The order dated
Hello,
19th August 2025. Wherein?
Lordship.
Yes.
I appear for the judgment debtor in this matter, Your Lordship.
Where is the affidavit?
Your Lordship, my junior is carrying it, Your Lordship.
Your Lordship. Sorry.
No, service has not been.
I'll just confirm that the senior and service. Okay?
Yes. It is who has filed this?
Direction was on
Pankaj Jain.
Pankaj.
And
Yes, Your Lordship.
Navneet Jain?
He is not traceable, Your Lordship. We have tried contacting him, but he is not traceable, Your Lordship. That is the issue.
Have you received the affidavit?
No, not yet, not yet.
Serve the
We'll
copy.
serve them. We'll serve them, Lordship.
Serve it. Learned counsel for the judgment debtor, namely Pankaj Kumar Jain, has filed. Judgment debtor, namely Pankaj Kumar Jain, has filed affidavit of assets in terms of the order dated 19th August 2025. After serving the copy to the learned counsel for the decree holder, let the same be kept with the record. Counsel for the judgment debtor submit that Mr. Navneet Jain is not traceable, and as such, she could not prepare the affidavit of assets on behalf of Navneet Jain. In view of the above, let warrant be issued against Navneet Jain. Navneet Jain, police of the petitioner, the decree holder is directed to take up a petitioner who file requisites in the department for issuance of warrant against Navneet Jain. Navneet Jain, within a week from date, returnable
1 week after vacation, my lord. By that time, my lord, my application will also
on
be
4th November 2020.
lodged.
Grateful to Your Lordship.
Next,
6 to 10, my lord.
6 to 10. Huh?
Address of the Navneet Jain is in my affidavit. Supplemented.
ওটা তোমাকে দিয়ে দিতে হবে।
দিয়ে দাও, address ও দিয়ে দাও। May I supply the address?
লক্ষ্য।
My application, my lord, in an execution application, my lord, I have been added as a applicant has been added as a judgment debtor in the proceeding below, on the premise that I am a partner of the firm. A partnership firm, my lord, is suffering a money decree passed by a 30,000 court, my lord, in 2010. Now, my lord, in 2011, the decree was transferred to the jurisdiction of Kolkata. The decretal amount was rupees 5,51,000 only. Now, my lord, it was not pursued thereafter. In 2022, the decree holder, my lord, straight away file a fresh execution application in a commercial division before this honorable court. Now, my lord, time to time matter appeared. Thereafter, a submission made from the bar that I have been, that I am a partner of the firm. Thereafter, they file an application. A GA1 application in 2023 was filed by the decree holder, later on withdrawn. In such application, it was prayed that I should be added as a judgment debtor on the premise that I am a partner of the firm. but later on it was withdrawn, and on the basis of submission, my lord, somehow, my lord, a warrant of arrest was issued against me, my lord. I was arrested, I produced, my lord, I deposited a certain amount. Thereafter, I filed my affidavit of assets, my lord. In affidavit of assets, my lord, I said that I do not have any connection with the firm. I am not a partner of the firm, nor I am driving any assets of the firm, my lord. Thereafter, my lord, I filed an application. This application, my lord, challenging, my lord. I have here twofold prayers, my lord. First, my lord, the execution application.
Which application? 3? GA?
2. GA2, my lord. Lord, 3 is recalling, my lord, where my lord my bank account has been attached. My lord, in this application, my lord, I am making twofold prayer. First, my lord, the execution application itself is not maintainable, my lord, under the commercial division, because first, my lord, the decree was passed in 2010, and it was also, even the suit was filed before 10 lakhs. So therefore, in any event, at best, this execution proceeding can be, by way of transfer order, can be executed by the learned city civil court, not by high court. And filing of fresh execution application.
Who is for the decree holder? Have you served?
Yes, it has been served.
Who is appearing for the decree holder?
My lord, Mr. Shaunak Bhattacharya, my lord, was appearing. Shaunak Mukhopadhyay, my lord.
Last occasion also none appeared. 8 September also none appeared.
After filing application, my lord, they are not appearing.
What is the GA3?
My lord, GA3, my lord, I have filed an application for recalling because, my lord, there is an order of attachment of my bank account.
Judgment debtor. Your judgment debtor. Who are you?
I have been made as a judgment debtor, but without any formal application, only by an order.
Mr. Surya Kumar
Yes.
Pandey. One Mr. Surya Kumar Pandey has filed
Yes.
2 applications, being GA-Com 2 of 2024 and GA-Com 3 of 2024, praying for a recalling of the order dated 3rd September 2024 and 24th of September 2024, passed in EC number 285/2022, and for dismissal of the present execution proceeding. None appears on behalf of the decree holder. It is found that on 8 September 2025 also none appears on behalf of the decree holder. Considering the above, for the interest of justice, the case is adjourned. Let the matter appear on 24th of June, 24th of September 2025, under the same heading. Under the same heading, it is made clear that on the date fixed, if the judgment debtor will not appear, appropriate order will be.
My lord, decree holder. Decree holder does not appear.
The decree holder will not appear. Judgment debtor holder. Decree.
Grateful.
Next.
May it please, my lords, appear for the applicant in the matter. My lords, as directed on the last date, we have served our application to the other side. They yet to file a reply in the matter.
We are on the behalf of the degree holder paying for a short passover led by Mr. Moinak Bose.
So you file affidavit?
It's a change brief we recently engaged 3-4 days ago.
Which matter? Moinak Bose is appearing since beginning.
This matter.
How you are telling that it is a change brief? Mr. Bose is appearing in before me for the last 1 year.
Mr. Bose will be appearing in the matter, my lord. He's asked us to take a passover, my lord. He's on legs in court 37.
So he's telling that it a change
He's
brief.
saying that there's a change in brief, my lord, but Mr. Moinak Bose will be here, my lord, to address the argument.
Not today. Next.
Number 13.
Lordship, 13 on Omnath Gangabadhyay, I'm paying for short passport. He's coming.
Not today.
Lordship, this matter is being adjourned.
You are appearing for whom?
I'm for the degree holder, my lord.
Give the one. Give. Yes. What is the matter?
My lord, in this matter, the judgment debtor is a company. The managing director, uh, he he was
The execution
arrested.
proceeding.
Execution proceedings.
Yes.
He was arrested and he was produced before the court.
What was the decree?
Decree
Where
was
is the tabular statement?
decree was for an amount of 53,61,000
Along with interest.
along with interest, my lord.
Yes. Has he paid any amount?
He has at the time of examination of the judgment data, an amount of 10 lakhs was paid, and the rest of the amount was
Paid an amount of 40 lakhs and took before this court that they will pay the balance amount till the amount.
My lord, out of that, only 4 lakhs have been paid, and that
14
amount.
lakhs.
10 lakhs initially.
Yes, 14 lakhs he has paid.
14 lakhs he has paid. And after that, no amount has been paid, and this amount was undertaken to be cleared by 31st of March 2025. My lord, we have been every time the matter appears, they pray for an adjournment and give an undertaking before the court that they will be paying off the money.
Yes.
Nothing comes from
Mr.
them.
Gangopadhyay is
Might be.
he can apprise your lordship. He's coming. He's on the way.
31st of July he has made an undertaking before
short
this court.
password. He's
No,
coming.
sorry. 31st of July he has made an undertaking before this court. Whether you are paying, have you instruction, whether take the instruction, I am waiting here. Take instruction whether you have instruction to pay the amount. Otherwise, I'll take prepared order for warrant.
Kindly give me a
No time, because today only the 12:30 is how the Passover.
Lordship, kindly.
Only you take the instruction whether he will pay, otherwise I'll pass a prepared order here in now. Take instruction.
Lordship,
Whether he will pay today, if it not pay, then I will pass a prepared order.
Their affidavit of assets which they have filed, it will show.
Before this court, you have taken an undertaking. Before this court on 31st of July, the balance amount is paid on the next date. Where is your judgment debtor?
Where is the judgment?
Today he is not present.
Okay, he will present. The decree holder has filed the present execution proceeding for execution of the decree for an amount of rupees 53 lakhs 61,505.
61,505.
505. Out of the total decretal amount, the judgment debtor has paid rupees 14 lakhs.
Yes.
Full stop. The matter was fixed on 31st of July 2025. On the said date, also none appears on behalf of the judgment debtor. But by an order, but on 21st of March 2025, when the matter was taken up for hearing, the counsel for the judgment debtor submits before this court that judgment debtor shall pay the remaining amount within fortnight. In spite of undertaking given before this court, neither the judgment debtor is appearing before this court nor has paid any further amount. Full stop. When the matter is called today, the learned counsel appearing for the judgment debtor prays for time. This court has inquired whether the judgment debtor is present, the learned counsel for the judgment debtor submit the judgment debtor is not present. Considering the last payment, when the last payment was
Last
made?
payment was made on 3rd of December 2020.
For the judgment decree holder submit that the last payment was made on 3rd of December 2024, and still since then no amount has been paid. Considering the above, this court find that considering the above, this court find that this is a fit case wherein the warrant can be issued against the judgment debtor, as the judgment debtor, in spite of undertaking given before this court, failed to pay the amount. Petition is let the warrant be issued against the judgment debtor. The decree holder is directed to take appropriate steps for filing requisites in the department for issuance of warrant against the judgment debtor. Let the matter appear on 4th of November 2025.
Okay,
Matter, my lord, I am for the decree holder, my lord. The matter appeared on, my lord, 9th on 30th June, my lord, when my learned friend praised time for taking instruction, my lord, for the how they will pay, my lord. As the prayer of the learned council of the judgment debtor, the case is adjourned, my lord. On that day, and my lord, my amount is
which matter you are Vicky?
Vicky, my lord.
No,
And
no, in
23
Vicky
lakh
I never.
37,000 as on 30th October 2024, my lord, and thereafter 12% interest, my lord. As on 30th August 2025, the amount comes to, my lord, 25 lakhs 42,000, my lord. They have not paid any amount, my lord, till date, my lord. They have filed affidavit of assets. Directors have filed affidavit of assets, but affidavits does not reflect anything, and no.
Okay, you examine.
My lord,
Examine the, if you want to examine the judgment debtors, you examine the judgment
on the
debtor.
last occasion, they have given that they
Where is the order?
No, my lord.
Where
Some
is the
wrong
order?
submission is there, my lord.
Where is the order? Order dated
20th June, my lord.
20th
They paid
June.
for time,
Paid
but
for time.
it was not.
Correct.
Yes.
They paid for time. No, they are not they are not paying the amount. Let you examine the judgment debtor.
No, my lord. one
That
thing.
means fixing a date for examination of judgment debtor. Yes, what,
My lord,
what is the course of action? You should tell me.
there are two applications are pending before your
I
lordship.
will decide all the things after the examination of the judgment debtor on doc.
My lord,
I will examine. One thing I
want to submit, my lord. All the directors were directed to file their affidavit of assets, but they have filed only on behalf of the company Senco.
No, my
And
lord.
the other directors said they have not filed, my lord, as yet, my lord.
Okay, who has filed? Let he come and examine.
Only the company has filed, my lord.
Yes, you filed against whom? Case is against whom?
Against the company.
Then
yes.
Company, then on behalf of the
Judgment
company,
dated is the-
let them come. Who is the authorized of the company? Let he come and examine.
My lord.
Then we'll see
That
the
director
court.
is,
Counsel for the decree holder submitted. Though the judgment debtor has filed the affidavit of assets, but has not paid any decretal amount till date. Considering the above, this court find that the judgment debtor has already filed the affidavit. Manitosh, kya hai?
My lord, there is one submission, my lord.
Yes.
The wrong submission is there because appeal is pending, my lord. Number one.
Appeal is pending.
Appeal has been filed.
Have you got the stay?
My lord, matter.
Have you got the stay or not?
My lord, no.
No,
But one thing, my lord, may I be permitted to say one thing, my lord?
Yes.
Matter has not at all come in the picture, not come in the board. So, my lord, it is
You
not
being
the
the senior advocates, you
appeal
know,
is
mayor
defective.
filing the appeal, mayor filing the revisional application will not.
March they have filed it. It appears as defective, my lord. Defective.
No, it was defective, but
Okay,
there
whatever it is, you show me the
defect
stay
has been
order.
removed, my lord.
You show the stay order, I will.
My lord, one thing, it is not that the stay order has been moved and it has been rejected or dismissed. Matter has not at all come in the picture, my lord. So one opportunity may be given so that we can mention the matter, my lord. So long it has not come in the picture, my lord. So, my lord, appeal is pending. So far, the judgment data is concerned.
18th November for examination of the judgment debtor. Yes.
My lord,
one contempt application has also been filed.
Contempt is different issue. Contempt is different issue. Contempt is not pending here.
Next.
My lord, my two applications are pending, my lord.
I will hear.
They are not the judgment debtors.
Okay.
But they have been directed to file affidavit of assets.
Okay, I will
but
hear
they
that.
are protected by corporate veil, my lord.
Okay, I will hear that. I am not telling that they may be arrested. I have passed an order for examination of judgment debtor who has filed the affidavit of assets.
My lord.
Then,
but one thing,
any coercive order has been passed against you.
No, my lord.
Then, yes.
My lord, one thing that appeal is pending. Please,
Maybe
lordship, please
you
consider.
You bring the stay order immediately. I will fix the matter after the puja vacation or out of the list. You bring the stay order.
It is lying defective, my lord.
No, it was defective.
You
but
bring the
defect
stay
has been
order
removed.
immediately. I will stay my order. You bring the stay order from the Supreme Court, I will immediately send the matter out of the
It
list.
is in division bench, my lord, not in Supreme Court.
Okay, from division bench you bring the stay order by side, only the one step
That
away.
is, so the vicinity is there, but actually procedure is
March
different.
you filed the appeal and today we are on August, September and
My lord.
Yes, call the list.
Item number 15. My lord, item number
Item number 15, I'm appearing, your lordship. Item number 15, there a settlement was going on. Part payment has been made in this matter. I must stamp for the judgment holder. I must indicate that part payment has been made.
My lord, we have already made the 50% payment. Some government dues are there. So, my lord, immediately that bills are clear, we will make the payment.
Counsel for the decree holder submits that the judgment debtor has paid part payment and settlement is going on. Accordingly, press for time. In view of the submission made by the counsel for the parties, the case is adjourned. Let the matter appear on 18th of November 2022.
I'm grateful.
Deeply obliged.
Next.
Item number 16, your lordship. On the last occasion, your lordship had directed for service to be effected through the district judge. We have made the necessary compliance, your lordship. My learned junior is in court.
Report आया है?
The service report is available, your lordship.
आप लोग पहले रिपोर्ट हम लोग का दिया करो ना, रिपोर्ट नहीं रखा हुआ है, हम पूछते हैं आपसे.
Service has been effected on the wife of the judgment debtor.
Yes. But
now, this is the matter that whether judgment debtor had not been present in the proceeding ever, despite repeated service and service through the process of the court. So you kindly pass appropriate directions for affidavit of assets.
No, if they are not appearing, have the affidavit of asset. Let the warrant be issued.
Let the warrant be issued in that event. Let the warrant be issued. We'll take appropriate steps.
Deputy Sheriff of Calcutta has submitted the report wherein it reveals that the notice of the present execution proceedings have been served upon the judgment debtor on 14th of August 2025. But in spite of receipt of the notice, none appears on behalf of the judgment debtor, no accommodation is sought for. In view of the above, let the warrant be issued against the judgment debtor. Full stop. The petition is directed to take appropriate steps to file requisites in the department within a week from date for issuance of warrant of arrest against the judgment debtor. Please the matter on 4th November.
I'm deeply obliged, Your Lordship. Deeply obliged.
Number 17.
I appear for the decree holder.
Lordship, I'm out of time. Your Lordship had granted me 7 days.
What for?
On the
file
last
the
occasion,
affidavit of
they
assets.
had filed a affidavit of asset, but not in proper form. So Lordship had given them 7 days time to file the affidavit in.
Lordship, I'm out of time. My affidavit of assets, though drafted, Your Lordship, it's not affirmed.
The judgment debtor prays for extension of time to file affidavit of assets in proper format. Time is granted. Let the affidavit of asset be filed by
Lordship, till Friday, if Your Lordship gives me.
this week will file.
Lordship,
By
that's my
23rd?
instruction.
By 23rd.
23rd, Your Lordship.
After serving the copy to the learned counsel for the decree holder.
Only difficulty is, my lord, they had handed over a copy of the affidavit of asset. Lord, there is nothing in the bank. Lord, there was a property which I had, my lord, we had
Okay,
found
let
out.
the file this file in the court. Then if I am fixing on 24th.
And let them also serve an advanced copy.
Yes,
my lord.
yes.
That's why after serving the copy to the learned counsel for the decree, let the matter appear on 24th
Right,
September. Next.
Number 18.
I am for the, my lord, decree holder. In this matter, my lord, though the judgment debtor has been served, none is appearing on behalf of the judgment debtor.
Where is the report?
My lord, the report.
Have you obtained report?
No, we have a service affidavit. My lord, may kind.
Have you served?
I have served by speed post, my lord. My affidavit of service is here.
What is the total decree?
The total decree was for, my lord.
Decretal amount is?
My lord, 17 lakh. My lord.
17,67,248.
Yes, my lord, that was the deposit.
That is
My lord,
deposit.
our claim today is
But that's why,
25
what is the
lakhs.
decretal amount?
17,24,000 plus interest.
It is the principal amount 70.
17,24,000. Yes, yes.
What is the percentage of the interest?
My lord, percentage interest was, my lord, 18%.
18%.
Yes, my lord.
18%. Where is the service report? This affidavit service?
My lord, affidavit service is there, my lord.
Where is the track report? Return unserved?
Yes, my lord. Because, my lord, they say that it's left. My lord, page 5.
Left.
Left.
So,
my lord, that would be, my lord, amounting to good service. And also, my lord, I've served by email. My lord, in the earlier affidavit, there was an earlier affidavit, my lord, where I've shown that I've served by email, and the email which is appearing in the MCA records. In the MCA records, my lord.
MCA record?
My lord, the Ministry of Corporate Affairs, this company, my lord, has a registered email address on which, my lord, I have served.
So they received? Have you mentioned in the affidavit?
The email, my lord.
Have you mentioned in the affidavit? No.
No, my lord, that
Then
is not mentioned.
you are not mentioned in the affidavit.
That is not mentioned. But that.
How many judgment debtor? One or two?
One, only one. One company, my lord, APL Metals Limited.
So what can be done?
My lord, any alternate, my lord, mode of service, if that can be granted, my lord, paper publication. Because, my lord, the difficulty is that this company, my lord, is about to go into insolvency. Already Section 7 has been filed, my lord, by Indian Bank.
So you made your claim before.
We are an unsecured operational creditor. My lord, your lordship knows what will be the fate of my claim.
But your amount is deposited here.
But that I have received. 17,64,000 I've received. I've withdrawn, my lord, by your lordship's orders. 8 lakh odd is, my lord, outstanding. Yes, interest part.
We are in the Calcutta itself.
Calcutta, my lord, it's in New Alipur. The registered address, my lord, even by the records of the Ministry of Corporate Affairs, the address is the same, New Alipur, where, my lord, we have served. And also, my lord, we have served on the earlier known address, which was at Hindustan Park. And even, my lord, page 7 of my affidavit.
Yes, I have gone through. So what is the prayer?
My lord, if my lord, some other mode of service, my lord, the paper publication, if that could be allowed. Because, my lord,
send through the district judge.
Very well, we can do that.
Who is the district? Alipur?
Alipur.
The decree holder has filed affidavit of service showing that the notice of the execution proceeding was sent to the decree holder, to the judgment debtor by speed post, but the same was returned unserved with the endorsement left. Counsel for the plaintiff, counsel for the decree holder, prays for an order for service of the notice of the present execution proceeding to the London District Judge of Alipur Court. In view of the submission made by the counsel for the decree holder, the decree holder is directed to take appropriate steps for issuance of writ of summons, issuance of notice upon the issuance of notice of the instant execution proceeding upon the judgment debtor to the district judge of Alipur. The petition is directed to take appropriate steps within a week from date. Let the matter appear on 11th November.
Very well. Grateful.
For the decree holder, my lord, this is the decree against Senco Jewelers, my lord. My learned friend appeared on the last occasion, my lord. In this matter, he wanted to take instruction, my lord. The order is there, my lord.
Yes. My lord, instruction has been taken, my lord. Today, the client is on the way with a check of 3 lakh rupees. So far,
check?
3 lakh.
Then again it will be
No, my lord, because on the last occasion I submitted that if there is waiver of the interest part, then by installment it will be paid, and how many installments to be given, that instruction I have to take from the client. My lord, if the interest part is waived, my lord,
I cannot. The court cannot. Court
my
passed
lord,
already
let
decree.
my learned friend.
That is up to you.
My
humble submission, my lord, the mediation was already there. If this could be submitted there, my lord, it could be settled there, my lord. But my interest part is 3,96,000 as on today.
What is the principal?
Principal is, my lord, 66,17,000.
So total 70 lakhs.
70 lakhs.
My lord, the client is on the way with I have already spoken to my client, my lord, and that my again repetition, my lord. If interest part is waived by my client, by my learned friend or the plaintiff.
7 to 8 lakhs, my lord. In another matter, your lordship granted them installments in 10 installments.
That is not my matter. I don't know.
May submit.
Then submit. Then I will submit.
They are paying, my lord. 10 installments of 3 lakhs, they are paying. In this matter, my lord, the amount is high, my lord. When I sold them gold, my lord, the 67,000 was the price, my lord. Now it is more than 1 lakh rupees. So, my lord, I have already in the loss, my lord. If I get the principal plus interest, I am in the loss, my lord. So, if they are paying let them pay with interest in installment, my lord. Kindly grant them pay installment in 5 installments, my lord. It's a 70 lakhs.
I don't know the other matter of which he is speaking, my lord. I don't know that matter. That is, I am not there, my lord. It is a fact that the gold price has gone to 1 lakh, more than 1 lakh rupees, no doubt. But at the same time, the condition of every gold merchants are now very much in stake, my lord. So, my lord, they are at stake, my lord. So, interest part is waived. I am ready to pay because I am ready to pay. Let the installment may be determined. And even not in equal installment. Sometime I may go to 10 lakhs, sometime I may 2 lakhs.
If you are ready to pay the principal amount today, I am
Today it is,
exchanging
my lord, your lordship, just try to understand, my lord. Just lordship, appreciate, my lord. Appreciate, my
without talking to the decree holder, if you are paying the total decretal amount here in now, I will discuss with your interest.
It is so high, my lord. It is just
they can pay. They can pay. They can.
That is his submission. They can pay, but we very much well are aware of the situation that they cannot pay right at the moment, right at this moment, my lord. My lord, it is very much high amount, my lord.
What is the very much amount? That is a decree.
That is
court has not given any.
I am a small jeweler in my office.
I am ready to pay immediately 3 lakh rupees.
3 lakhs.
No, not 3 lakh. It is full stop is here. It is not that it is full stop. I will proceed. Let him consider. And your lordship may also please, because your lordship cannot do anything. That is your lordship. I know.
If you pay the 7 lakh at a time, now today bring the
today 7 lakh is impossible, my lord. 3 lakh is, and I have not spoken about immediately 3 lakh may be paid today. He is on the way, maybe stuck in the rain.
The 3 lakhs if you pay the 7 lakh today itself.
My lord, 7 lakh, it is just to appreciate, my lord. Please appreciate. 7 lakh he has already started so far.
Okay.
My lord.
Just what is the submission?
That is my submission only. I have already submitted that we are ready to pay in installments.
See that is up to the judgment.
That is up to
decree holder. If the decree holder accept, then I will record the
Let them
terms.
take instruction. Kindly make it not today. Let them take final instruction for how they will pay, my lord, because my client needs money, my lord.
He is telling that if you waive the interest, then he will pay the total amount.
I leave it to your lordship, my lord. Whatever your lordship feels, my lord, I leave it to your lordship, because it comes to about 3,96,000. Whatever your lordship feels, my lord, I will leave.
So 70 lakhs when you pay?
My lord, fix it by installment, my lord.
70 lakhs rupees?
70 lakhs with interest, my lord. So please consider about without interest, my lord, because he has already said that discretion has been given upon you.
Principal is the 54 lakhs.
Principal
4 lakhs.
Principal is 53 lakhs 65.
Correct. 54 lakhs.
Interest thereon 11,52,000. So total amount comes to 66 lakhs 17,000. And thereafter, mala interest up to August, because decree was passed in January, my lord, and thereafter interest was passed 3,96,000 for 4 months, my lord, and cost of rupees 1 lakh, my lord. I have already.
Have you paid any amount today?
No, he's with the check. Yes, maybe with the for the rain outside and in North Calcutta for the rain outside. He's stuck on the way, my lord.
Bhau Bazar, my lord, sir.
Anyway,
He's out of Calcutta. Bhau Bazar is out of Calcutta.
My lord.
Not even 1 kilometer, my lord.
No.
He's telling the Bhau Bazar is out of Calcutta.
It is raining, my lord. I have left my car.
Yeah, Bhau Bazar, there is a rainy.
It was raining, my lord.
When it started?
When I was just near the Raj Bhavan, not Raj Bhavan, even up before Akashbani. At that
How
time,
you reach that Raj Bhavan today?
on foot, my lord. I have left my car, my lord. I was totally wet, my lord.
You've been allowed the traffic to go to the Raj Bhavan today?
My lord, I have come through that way. That means from, my lord, your lordship is just, I am sorry to, I am sorry, my lord. Your lordship is most probably doubting about my submission, but it is not the fact. Raj Bhavan means I want to mean that from the Akashvani Bhavan that side. From Akashvani Bhavan, and I was repeatedly called by my junior. That is different. No.
Okay.
That is different issue.
Okay, come
I am
tomorrow.
sorry to.
Okay, today your client is come tomorrow with the payment.
My lord, from tomorrow, my client, today, sorry, my lord, today itself he will come. He is on the way, my lord, and he will bring.
Paso.
My lord, another thing, my lord, tomorrow, my lord, for health reason, I am not able.
Taking fast over, let your client come and mention. We'll see to that. If it is before 12:30. Yes, call the matter.
My lord.
My lord, my application for execution, my lord, decree passed by your lordship. My lord, on 8th May, your lordship had passed directions, my lord, directing the judgment debtor to file the affidavit of assets. My lord, not filed. My lord, on the last date, after we had filed the application, my lord, they have handed up a check of rupees 2 lakhs. Your lordship permitted them to pay in 10 installments, my lord, at a lower rate of interest than what we had claimed. However, my lord, they have not paid. My lord, today, my lord, I was praying. On 8th May, your lordship had passed directions for filing of. Yes, your lordship. And my lord, orders of injunctions were also passed in respect of 2 bank accounts. Your lordship will kindly see paragraph 4.
Yes.
My lord, I was praying, my lord, that my lord, a warrant of arrest be issued. My lord, they have not made payment. And let them also, my lord, disclose the bank statements in respect of these 2 accounts.
They are operating. We have information.
Lord, we have been instructed that these are being operated.
Clear how they are misleading the court. 28 July order. They have categorically said they will clear. They have done paid nothing. That 2 lakh at initial they have cleared and then nothing.
My lord, even as on 28th July, my lord, they had submitted that they will clear all the dues. My lord, nothing forthcoming.
Paragraph 4.
At paragraph 4, your lordship has also been pleased to record the submission of the judgment debtor.
Just dodge, they're just evading. I think they're not
Lord,
appearing now.
Lord, this is, my lord,
What is the total decretal amount?
Yes, my lord, the total decretal amount is, my lord, 31,30,337, including interest.
As on April, now it has increased further.
My lord, as at April, when we had filed the execution, my lord.
19 lakh principal.
Yes, and my lord, 12,07,616 is the interest.
What they are doing is the station is
the none appears on behalf of the judgment debtor. On 28th of July 2025, the judgment debtor has paid a part amount of rupees 2 lakhs to the decree holder and submits before this court that the judgment debtor will clear all the dues by September 2025. Today, when the matter is taken up for hearing, none appears on behalf of the judgment debtor and no accommodation is sought for. It is submitted by the decree holder. Other than the 2 lakh rupees, the judgment debtor has not paid any further amount. The judgment debtor further submitted, the decree holder further submitted, in spite of the interim order passed by this court, dated 8 May 2025, the judgment debtor is operating the bank account as mentioned in order dated 8 May 2025. Concerning the above, the judgment debtor is directed to file affidavit of assets by 29th of October 2025. This is the matter on 29th of October 2025.
My lord, they are evading. My lord will kindly indicate that the directions are peremptory and what.
If they will not file, then we'll see to that. It is made clear that on the date fixed, if the judgment debtor will
Lord,
not
let
file the
warrant
affidavit
be
of asset and not appear
in the
before
court.
this court, appropriate order will be passed. Yes, next.
Item number 21.
Item number 21.
My lord, I appear for the judgment, decree holder, my lord.
Yes.
The plaintiff decree holder.
Yes.
My lord, I am appearing for the judgment letter number 6 and 7 in this matter, my lord. My lord, there was a direction, there was an order passed on 18th of August 2020.
Behalf of my lord, respondent number 4, my guardian senior,
My lord.
Orin Chakraborty for this matter, my lord, he's not in, not come to the court, my lord. I'm praying for all.
My lord, if you see the last order, my lord, just respond number 4 was directed to
You are
file
appearing for whom?
the affidavit of assets.
My lord, he is assisting me, my lord. Mr. Sanu is assisting me. My lord, on the last occasion, there was a direction, my lord, for filing of affidavit of assets, my lord. It has only been forthcoming from the defendant number, the judgment debtor numbers 6 and 7.
Defendant number 4.
Yes, my lord.
Where is he?
My lord, he's suffering from high fever, my lord.
Ah. Which police station is residing? I am bringing today itself. On that day, he undertake before this court. That's why I release them on personal ground. Which PS? Immediately tell. Which PS is residing? On that day, voluntary surrender and your senior who made an undertaking, he will appear before this court and file the affidavit. Where is he? Now he is suffering from fever.
No, my lord.
Which PS is residing? I am directing. Let me bring on at 3 p.m.
Only not today, my lord.
Which year you are having a practice from since when? Have you gone through the order? And your senior has sent you. Who is your senior?
Orin Chakraborty, my lord.
You go through the order? You have the order? Serial number 3.
Now, for the judgment letter number 4, establishes that he will file affidavit of assets on the.
Yes, where is affidavit of asset?
I will file, my lord, only not today, my lord.
If you file undertaking within 1 hour, I will allow. Otherwise, I will pass an order for today. He has to brought under arrest. Today has to brought under arrest.
I am paying for short password, my lord. I am
Sorry.
taking my lord instruction from him.
I know the seniors, how the seniors dealing with the matters. Sending the junior before this court for taking time, knowing that what is the order passed by this court. Can I refer the matter to the bar council? You junior persons are appearing before this court without going to the order. Our senior is taking the benefit of the juniors. On that day, he humbly prayed before this court that he has voluntarily surrendered. He will file the affidavit of asset by the next date fixed. And this court has released on personal bond. And today you are again. Yes, what about the other?
My lord, 6 and 7 has filed his affidavit of assets, my lord. My lord, on 1st of September.
1, 2, and 3, I have taken out the application. My clients reside in Bangladesh. So we have taken out the application for transfer of the that part of execution proceeding in the jurisdiction where my clients are residing according to the provisions of Code of Civil Procedure. That is application.
My lord, perhaps that is not the prayer which has been made, but nonetheless, my lord, I would like to file an affidavit to that extent.
As that is the court, that has to be anyway.
Which application? Application number?
Give that IAG number 1 of 2025.
You will file affidavit?
Yes, my lord, I'll use an affidavit in opposition.
The judgment debtor number 1 has filed an application being GA-1 of 2025, praying for dismissal of the present execution proceeding. Full stop. The judgment debtor number
6 and 7, my lord.
6 and 7 already filed the affidavit.
My lord, on 1st of September 25.
The prayer D of the
already filed affidavit of assets.
prayer D of the application is alternative prayer.
Already filed the affidavit of assets. उसमें ऊपर है ना, dismissal of the present execution proceeding, or in the alternative to transfer the present execution proceeding before the appropriate court having jurisdiction to execute the judgment and decree passed by
My lord,
the. And what about the 6 and 7 you filed?
my lord, I have
And
filed.
what
My lord,
about
a copy of the application may be served on us.
Which
My lord, the
application?
one filed by different.
What do you
My lord,
will do?
there might be some
And what
submissions
about
made.
the 3? What about the 3?
My lord, 1, 2, 3 has taken out this application. 4 has not filed any affidavit of assets, nor 5 nor 8.
Judgment after number 4. Press for time. This court find that on by an order dated 1st of September 2020, no, not 1st September. When the warrant was
2nd September, my lord.
Huh?
2nd September.
2nd September.
Warrant was issued.
My lord, 18th of August,
That was 18th of
2025.
August, my lord.
By an order dated 18th of August 2025, this court has issued warrant of arrest against the judgment debtors number 4 to 8. And accordingly, the judgment debtor had surrendered before this court on 2nd of September 2025 and undertaken before this court that he will file the affidavit of assets on the next date fixed. Accordingly, this court has released the judgment debtor number 4 on personal bond with the direction to appear before this court. Appear before this 9 September. Today, watch your date. Appear before this court and also to file affidavit of assets on the next date fixed. Today, when the matter is called, neither the judgment debtor number 4 is present in person, nor has filed the affidavit of assets. The counsel for the judgment debtor number 4 prays for time. Taking into consideration the act of the judgment debtor number 4, this court find that in spite of specific time granted by this court, the judgment debtor number 4 failed to file the affidavit of assets. Accordingly, warrant be issued against the judgment debtor number 4. Full stop. The petitioner, the decree holder is directed to take appropriate steps for filing requisites in the department for issuance of warrant of arrest against the judgment debtor number 4. Full stop. The counsel for the decree holder prays for time to file affidavit in opposition to the application filed by the judgment debtor number 1, 2, and 3. Let affidavit in opposition is filed by
2 weeks.
2 weeks after puja vacation. A reply, if any, there to be filed within a week thereafter. Police released the matter on 25th of November 2025.
My lord, if 6 and 7 could also be directed to be there on that date. They have filed their affidavit of assets.
I will see to that.
Oblige.
Great, Vimal.
Your Lordship.
Lordship, I am for the decree holder in item number 22. On the earlier occasion,
yes,
an order was passed that the decree judgment debtors would pay an amount of 2,50,000, and thereafter on August 18 would pay 5 lakhs, and thereafter today, September 15th, they would pay the rest of the amount. But they have not paid onwards 5 lakhs or the rest of the amount. But I am under instructions that the parties have had a communication. They say that they will pay. So Lordship kindly keeps it after 1 week and can be proceeded.
As per the prayer made by the counsel for the decree holder, the case is adjourned. Let the matter appear on 28th of October 2025. Next.
Your Lordship, I intend to mention item 20. I just got struck off in the traffic. If I can record my presence, Your Lordship.
Which matter?
Item 20.
It was this matter, my lord, wherein they, my lord, had consented to pay installments.
You
My
have
lord,
not
trial
paid the
state,
amount.
they have not.
Your Lordship, we have
No,
tried
thereafter
since
they
20
just paid 2
September,
lakhs.
and the mother of the judgment debtor has passed away.
Okay, you pay, then
Yes,
come.
Your
Let them, my lord.
You pay and come.
Your Lordship, kindly record my presence.
No, I will not record. I've already passed an
Always
order.
promises being made. My lord,
You want to pay the amount, you pay and come.
Your Lordship has recorded that twice. By September, they are
Yes,
supposed
next.
to pay.
Item number 23.
They appear for the petitioner, my lord, my execution application. Now the decree, the
The decree is at page 38. This is the court of the first instance.
59,28,000, 59 crore.
Yes, yes. This is 59 crores, and the decree is passed by the court at Dubai. It's 50th, page 38.
So how this court can execute?
Yes, this court can execute.
Where is the order? Where is the decree?
Page 30, page 38. Affidavit affidavit. Page 38 is the order of the court of first instance. This is the court of the first instance. I don't know affidavit, and this was taken up an appeal by the defendant. Now the appeal court's order, though referred in the tabular statement, let me come back to tabular statement. The column number 3 refers to an order of 29th of June 2020. Column number 4 refers upheld in judgment an order of 18th of May 2022. So this is a court of appeal. The court of appeal order we missed, my lord. I have put in with a translated copy. This is the court of appeal. It was dismissed with cost. Now, notification. This is at page 14. Say it, yes. The internal page 14. We have done the English translation. The court ruled on the subject of the part and subject of with upholding the appeal judgment as to its ruling handing down against the first appellant, Abhay Narendra Lodha, and the court ordered with obligating him with the prescribed charges and expenses jointly with the rest of the appellants, in addition to paying an amount of the AED is dirham. I think Arab Emirates dirham must be 1,000 dirham for the advocate's fees and other charges. And this is the appellate court's order. Well, if we page 6, and
so how this court can execute?
Yes, under section 44A of the civil procedure.
It is transferred from there.
Yes, they have given a certificate. Yes, I have annexed page 61. Page 61 is a certificate by which the certificate required under page 61. Yes, page 61 is a certificate of the Court of Enforcement. Page 61, it is saying the Dubai Court first instance certified the judgment in personam, and the owner of Red Global Limited and the Blue Air Global Limited has filed averment execution application against the judgment debtor. Upon reviewing the system, it is found that no payment has been made and the procedures are still in progress. This court this certificate has been given at the request of the judgment debtor and judgment creditor, without the least liability on the circuit towards third party. So this is a certificate which they has provided for non-satisfaction certificate, which is required. Now we'll see 44A. Which now there is a reciprocating treaty between India and UAE that I'll place. Treaty is now 44A, where execution of decrees passed by courts in reciprocating territory, whereas certified copy of a decree of any of the superior courts of any reciprocating territory has been filed in a district court, the decree may be executed in India as if it has been passed by the district court. Together with a certified copy of the decree shall be filed in certificate of such superior court stating to the extent, if any, to which the decree has been satisfied or adjusted, and such certificate shall, for the purposes of proceeding under this section, be conclusive proof of the extent of such satisfaction or adjustment. 3 is the provisions of 47 that will be applicable. Provision 47 shall, as from the filing of the certified copy, shall apply to the proceeding of the district for execution of the decree. Now, explanation 1, Malan. Reciprocating territory means a country or territory outside India which central government may, by notification in the official gazette, declare to be a reciprocating territory for the purpose of this section, and superior courts with reference to such territory means such courts as may be specified in the said notification. Explanation 2. Decree with reference to a superior court means a decree or judgment of such court under which a sum of money is payable, not being a sum of money payable in respect of taxes or other charges, of a like nature or in respect of a fine or penalty, but shall in no case include an arbitral award, even if such an award is enforceable as a decree or judgment. And 45 is passing in India, execution abroad. So 44, the reciprocating treaty is the most important, then only we can do it. Remember the, sorry, the printout. I'm very sorry, we should have. This is the reciprocal. আমার কাছে তো copy নেই এবার. Any event, I'll tell you, I have to serve them because this is 2020. We had made a email.
Which court of order judgment is there?
This is Abu Dhabi. Abu Dhabi. This is the government of Dubai. Government of Dubai. Dubai.
Which
Dubai
court? Which court?
Courts of first instance.
Court of first instance. What is the court? Because here is the court, local courts, federal court, and local court. Local court is Abu Dhabi, Dubai courts.
Yes,
Ras. Where is the decree?
Page 38. Page 38. And in the name of His Highness, the ruler of Dubai, is 38.
Dubai court.
Yes, it's Dubai court of first instance.
Dubai court.
And this covers the entire UAE. The
Dubai court is given.
The 5.
Dubai court. CPC following the court of urban UAE. Superior court center. Yes.
So this
notice.
Yes, we have now the respondents, that you will see, they are at Brabant Road. The address.
Where?
Yes, the cost settlement, the execution cost. The execution. The execution cost settle.
Local Kolkata.
Yes, yes. Shondeep Chaudhary, and this is city center. Sorry, I am at Brabant Road. We are doing business over there. This city center, 19 Synagogue Street, Calcutta 1. And this is all in this Calcutta 1 only. 19 Synagogue Street, Ashwin Narayan Lodha and Abhay Narayan Lodha. His name appears in the decree. And the list of the properties also are within. I have given page 6.
Decree holder has filed the present execution proceedings for execution of the judgment and decree passed by the judge of Dubai courts in Dubai courts of first instance in the lawsuit number 2661/2018 commercial plenary plenary dated
29th of June, just above the name of the below the name of the ruler. 29th June 2020.
Dated 29th of June 2020. 29th of June 2020. The plaintiff is directed, the decree holder is directed to issue notices upon the judgment after returnable by 11 November 2025.
So they are assisting us. This whatever.
11 November 2025. This is the matter in 11 November. The decree holder is directed to file the affidavit of service on the next date fix. Hello, there, Babu. Next. है क्या मेंशन करो डेट दे दी कल भी है दे दो कौन कौन
Fixed matter at 11:30, item number 2.
Item number 24, my lord. I am appearing for the defendant applicant, my lord. This is my application for release of the bank guarantee, my lord.
Let it come tomorrow.
Well, tomorrow, if it retains its position.
It's fine that the matter is already fixed. Item number 2. It is fine that the matter is already fixed tomorrow. Let the matter appear tomorrow at 11.
Grateful, my great.
Sorry.
Next.
Well, in item number 24, my lord, I am appearing for the dependent applicant, my lord. This is my application for release of the bank guarantee, my lord. On the other day, it was my fault. I could not produce the copy of the service track report, my lord. My lord, today my junior is there is giving the track report, my lord. The suit has been dismissed for default on 13th March 2024, my lord, and no restoration application has yet been served upon us. And the bank guarantee, my lord, I have given as per direction of this honorable court, my lord. Time to that has been extended. Lastly, we have submitted the.
What do you have
I've handed over the track report.
Track report, my lord, service of the applications, my lord, upon the other side, my lord.
This is the way.
Lordship, the affidavit.
Affidavit of service has been filed, my lord. Affidavit of service has been filed, but only with the postal receipt, my lord.
Where you stated that they are not prepared any application for review of the for recalling of the order. Which
Recalling the order, my lord. Yes, my lord.
Where you stated?
Yes,
Where
my lord.
in your application?
My lord.
Para 8.
Huh?
Para 8, Lordship.
Para 8. Defendant stated when the dismissal did not file any bank. Did not file the bank guarantee which expired in the month of. Where is the content that they have not filed any application for recalling?
Paragraph 7, my lord. Page 4, paragraph 7. Page 4, paragraph 7, my lord. The no intimation of filing any approved application subsequent to the solemn order just transfer has been filed.
Which order the court has directed to file the deposit the bank guarantee?
My lord, last order of renewal, my lord, that is at page 8. That is at page 11, my lord.
Page 11.
Sorry, my lord. Sorry, page 13, my lord. Page 13. Prior to that, the order was going on, my lord. It was again we have been rejected.
No, it is extended. So it is in place. We mentioned bank guarantee in question has been extended at the instance of. Where is the bank guarantee? By which date? By which order the court you have deposited the bank guarantee?
On last bank guarantee, my lord, we have deposited. That is.
Which order the court has passed an order for deposit the bank guarantee?
Sorry, my lord. And that is the order passed by the Justice Kullanjali Sengupta, my lord. That is.
Bank guarantee in question has been extended at the instance of the defendant. Where is the order?
30th May 2006.
Yeah.
Copy of the order.
My 30th May, my lord, 2009, my lord. It's not written, my lord. That's my fault, my lord.
So by this is order when you have deposited, when you furnish the bank guarantee.
My lord, page 14 onwards, my lord.
14.
Last bank guarantee in 2023, my lord.
No, this order is passed on 2006.
Yes, my lord. We have been filed and renewed time to time each and every year, my lord. Lastly, we had filed the bank guarantee. That is page 14 onwards, my lord. With the Lord Register of this Honorable Court, my lord.
So whether the bank guarantee is still with the registrar?
Yes, yes, my lord. Yes, my lord. We have not withdrawn, my lord. We could not withdraw unless leave of this Honorable Court is granted to us, my lord.
Let the report be called for.
My lord. My lord.
The defendant has filed the defendant.
Yes, my lord. The sole defendant.
Present application being GA Com 10 of 2025, praying for direction, praying for an order allowing the defendant to withdraw the bank guarantee submitted before the learned registrar original side of this court in terms of the order passed by this court dated 30th May 2006, which was extended from time to time. Counsel for the defendant submitted the last guarantee was extended, last bank guarantee was extended on 10th 11.
Yes, my lord.
Extended
10th of November 2023, my lord.
of November 2023. He submitted as the suit filed by the plaintiff is dismissed for default and the plaintiff has not filed any application or the defendant has not received any application for restoration of the suit. Accordingly, the defendant prays for withdrawal of the bank guarantee from the registrar original side of this court. At the London Council for Full Stop, the defendant has filed affidavit of service showing that notice of the present application is also served upon the defendant and to the plaintiff, but in spite of service of notice, none appears on behalf of the plaintiff. Before passing any order for allowing the defendant to withdraw the bank guarantee of 15 lakhs, it would be appropriate that a report is to be called for from the registrar original side of this court whether the bank guarantee is lying with the registrar of original side of this court or not, and from the मनुतोष कौन बताएगा सूट रजिस्टर हुआ नहीं हुआ and the registrar is क्या बोला registrar of this court lying with the registrar side or not. The registrar side is also directed to submit report whether the CS number CS Com 26 of 2024 within bracket old CS 339 of 2001 is restored or not. Let the report be filed by 24th of June 2025. List the matter on 25th of June, September. Filed by 23rd of September 2025. List the matter on 24th of September 2025.
I'm grateful.
Can I get the order to
give the copy? Bring the copy and an exit. Yes, next.
Item number 25.
My lord, I pray for leave to appear through online, my lord.
Yes.
Your lordship, this is an application for extension of time of the commissioner who was appointed for recording the evidence of the plaintiff, my lord. At that point of time, the defense of the defendants were struck out. My lord, the evidence was recorded on several occasions and it was last recorded on 25th of April 2024. I have pleaded that in paragraph 7, my lord. Thereafter, the defendants had made an specially petition for for being allowed to file the written statement, my lord, the defendant number 1 to 4 have been allowed. Now, my lord, if the mandate of the commissioner is extended, my lord, the rest of the affidavit examination in chief of the witness of the plaintiff have substantially been done, my lord.
No, I mean, what you have prayed for in the Master Sermon?
My lord, prayer C, extension. My lord,
inspection completed.
My lord, I
My lord,
don't.
not completed. My lord, not completed.
My lord, subject to correction by my learned friend, the written statement, this is a commercial suit.
Correct.
My lord, the written statement does not annex any document. So it can be presumed that they are not relying on any documents, my lord. My lord, my documents have already been filed with the commissioner, which they can take inspection of from the original is with the commissioner. It is already on the records.
Yes, who is appearing for the defendant?
I'm appearing for the defendant 1 to 4, my lord. I'm led by Mr. Partho Banerjee.
And plaintiff?
But I appear for the plaintiff.
But I am appearing for the plaintiff.
Led by Mr. Murji, my lord.
So, who has filed this application? You filed the
My lord,
application.
I have. The plaintiff has filed this application, my lord.
Not wait for direction for inspection of the documents on the defendant. Take inspection of that has been completed. Prayer A is completed.
No, my lord, because after since 25th of April 2024, no further recording of evidence was done. Thereafter, my lord, they had made an application before the Supreme Court praying for liberty to for grant of leave to file their written statement. My lord, it was done, and your lordship has passed an order on. If your lordship takes up page 261, my lord, the second volume, when it was recorded that the written statement on behalf of the defendant number 1 to 5 has been taken on record, and the written statement of the defendant number 5 who was not allowed was returned. My lord, thereafter nothing has happened. So if my learned friend wants to take inspection, my lord, he has to take inspection of the original documents which is there on the records, because they have already been tendered.
Yes. So the written statement dependent number 1 to 4 has been accepted. So
Yes,
whether you will take inspection of the documents, sir?
My lord,
My lord,
they have not produced any other document. This is the
whether you will produce any document.
Yes, my lord.
Are they entitled to in a commercial suit at this stage?
You have not disclosed. You have disclosed the document.
Yes, my lord. I'm led by Mr. Banerjee in this matter, my lord.
Then,
My lord, Mr. Banerjee is appearing on
yes,
that.
sir. You have not disclosed any document in the written statement.
my lord, we have not, but my lord, we will disclose some documents.
My lord, in a commercial suit, they are not entitled to.
Under which provision of law you have not disclosed the written statement document in the written statement? On which provision of law you will disclose?
My lord, at least we will take inspection of their documents, my lord.
That's why I'm asking you, inspect. By which time you will complete the inspection? Tell me, I am fixing a date.
My lord, within 2 weeks, my lord, we will do that. We will complete that.
So, what further prayer is required, madam?
My lord, extension of time mandate of the commissioner. My lord, prayer C.
What is the last date for filing report by the commissioner?
My lord, that was long time back. It has expired. It was in June 2024. My lord, your lordship will find the order at page 80 and page 82. Your lordship will file that it was to be filed by 14th of June 2024.
Thereafter, no extension.
My lord, thereafter nothing was recorded because it was only in April 2024 when last recording was done.
Counsel for the plaintiff submit that though the defendant number 124 have filed the written statement, but in the written statement they have not disclosed any document, and as such, disclosing of document by the defendant number 124 does not arise. The learned counsel for the plaintiff submits that if the defendant number 124 intend to take inspection of the document of the plaintiff, they can take the inspection of the document of the plaintiff within a week from date. Learned counsel for the defendant number 124 prays for 2 weeks time to take inspection of the document of the plaintiff. Accordingly, the defendant number 124 is given liberty to inspect the document of the plaintiff,
which is already on record, my lord.
Take within 2 weeks, then it will go after vacation.
Yes.
Within week after puja vacation.
My lord, your lordship will record that the documents have already been tendered and it is in the record of the court.
ऊपर क्या बोला? Plaintiff full stop. बाकी काट दो. Counsel for the plaintiff submit that the documents which the plaintiff is relying upon are on record with the commissioner. Where
yes,
it is?
my lord, it is with the commissioner, but the court officer takes the record to the commissioner.
That will not be, but that not with an original one.
Original is there, which with the court entered before the commissioner.
Learned counsel for the plaintiff submit that the document which the plaintiff is relying upon is already on record of this court. Accordingly, the defendant is directed to complete the inspection of the document from the case record of this court within a week after the puja vacation. Full stop. Counsel for the plaintiff further submit that time to complete the evidence of the parties by the commissioner may be extended. She submit that by an order dated 5th of December 2023, this court directed the commissioner to complete the examination of the plaintiff first witness by 14th of June 2024. But in the meantime, the same could not be completed.
My lord, may I intervene once? My lord, by an order dated 28th of February 2024, my lord, which is at page 80.
80?
80. Annexure C, my lord.
Okay. 20th February. Yeah, 20th February, this court directed the commissioner examination of the plaintiff's first witness by 24th of May 2024 and directed to place the matter before this court on 14 June 2024, but the same could not be complied with as the witness was not examined. Accordingly, counsel for the plaintiff prays for new guidelines so that the examination of the plaintiff first witness can be examined before the commissioner as early as possible. Made by the counsel for the plaintiff. How much time it will take, madam?
My lord, they have to cross-examine. My chief is almost complete.
Counsel for the plaintiff submit that the examination in chief of the plaintiff witness is all completed. We have only the almost completed. In view of the above, time to file. In view of the above, the commissioner is directed to complete the examination of the plaintiff's first witness on commission by 11th of December 2025 and to file the report before this court on 17th of December 2025. Let the matter appear on 17th December for filing report by the commissioner under the heading to be mentioned. So this it can be disposed of.
Yes, my lord.
Yeah. The CA number and the GA Com 9 of 2025 is disposed.
Deeply obliged, your lordship.
My lord, issues might have to be framed, my lord. Should issues
My
have
lord, that can be framed after completion of the evidence because it is the court has to frame the issues, my lord.
One then come. Yes.
My lord, I'm awaiting for the defendant in this matter. This is an application seeking extension of time to file my WS, my lord, written statement. The written statement is already on record. My lord, it has been filed on 4th of July 2025, my lord.
We are for the defendant.
My lord.
Sole
Sole dependent.
When you receive the writ of summons?
My lord, on 7th of March 2025.
7th of March of 2025. Then, when you affirm the written statement?
My lord, it was affirmed and filed on 4th of July 2025 on the 120th day.
It is 120th day?
Yes. Yes,
Or after that?
No. Before. Yes.
120th day. 120th day. Where is the written statement?
My lord, it has already been filed.
Yeah, department aaya kya?
My lord, on 4th of July 2025, it has been filed.
You have not taken the backside page at the time of filing of this written statement. You have not taken the Xerox copy.
My lord, an order has already been passed.
What?
Which records, my lord?
Written statement may be kept in the record subject to or any other order. 4th of July.
My lord, 4th of July, my lord.
Yes, what is the submission?
It's on time, my lord. We have nothing.
The defendant has filed the present application being GA Com 3 of 2025. Praying for extension of time to file written statement. Counsel for the defendant submit that the defendant has received writ of summons on 7th March 2025. To the father of the defendant, as the defendant was at abroad for the purpose of for the business purpose. When the defendant returned back on 12th of March 2025, and immediately the defendant has contacted the learned advocate to represent the defendant. The learned advocate on record of the defendant has instructed the defendant for instructions as well as the documents so as to enable the learned advocate to prepare the written statement. By that time, the 30 days for filing of the written statement was over, due to which the written statement could not be filed. Counsel for the defendant submitted, though the defendant could not file the written statement within the period of 30 days, but has filed the written statement, but has affirmed the written statement and filed the same with the leave of this court on 4th of July 2025, that is on 120th day. 120th day. Police counsel for the defendant submits that as the defendant has filed the written statement within the 120th day, that is within the outer period as prescribed under law, and as such he prays for acceptance of the written statement. Per contra, an advocate appearing for the plaintiff raised objection and submit that the defendant has not shown any cause for non-filing of the written statement within the period of 30 days, and he prayed for rejection of the application. Had the learned counsel for the respective parties peruse the materials on record. This could find that the defendant has categorically stated that when the writ of summons was served upon the defendant was not in India, and the same was served upon the father of the defendant. Immediately when the defendant returned back from the abroad, has contacted the advocate, and as per the instruction of the advocate, the defendant had searched all the relevant document which requires in the present suit. By that time, the 30 days time was over. Though the defendant has not filed the written statement within the period of 30 days, but has filed on the 120th day. Thus, this court finds that one opportunity should be given to the defendant to file written statement subject to payment of cost of rupees 5,000 to the High Court Legal Service Authority. The defendant is directed to pay the cost of rupees 5,000 in the High Court Legal Service Authority within a week from date. Police stop. The department is directed to accept the written statement subject to scrutiny by the department, and the defendant directed to produce the evidence before the learned master for payment of cost as directed by this court. The defendant is also directed to serve the copy of the written statement to the learned counsel for the plaintiff within a week from date. GA number
Obligation.
Next.
My lord, item number 27, my lord. I am appearing for the defendant applicant 1. This is, my lord, an application for extension of time to file the written statement, my lord. My lord, I have received the writ of summons on 4th June. My lord, 120 days, my lord, is expiring on 3rd October, my lord. I have already affirmed the written statement, my lord, and my lord, written statement, my lord, is ready to be filed.
Where is the written statement?
I have not been.
Okay. Have you served?
No, my lord, it has not been served at.
Okay. Why you not filed within 30 days?
My lord, the case, my lord, is the transaction, my lord, is the instant suit is relates to, my lord. My lord, is a very old transaction, and my lord, the case, my lord, is that the dispute between the parties which, my lord, the plaintiff has espoused in this plaint, my lord, in this case, my lord, was settled between the parties previously.
Okay.
And my lord, after settlement.
My lord will not record my consent.
Defendant number 1.
Only the sole defendant.
Sole defendant. The defendant has filed the present application being GA Com 2 of 2025, praying for acceptance of written statement. Counsel for the defendant submit that the defendant has received the writ of summons on 4th of June 2025 and has entered appearance on 26th of June 2025. He submits that after receipt of the writ of summons, the defendant has contacted the present advocate on record, and advocate on record has instructed the defendant for providing supporting document for preparing written statement. He submits that the claim made by the plaintiff is old one, and as per the instruction of the defendant that the transaction between the parties were closed and settled long back due to the amicable settlement arrived between the parties. That parties now the plaintiff has initiated the present case for the purpose of tracing out the old document. The defendant has took some time, due to which the defendant could not file the written statement within the period of 30 days, but has affirmed the written statement on. Where is the affirmation? On 6th of September 2025, that is within the outer period of 120 days. He submitted that full stop. Full stop. Learned counsel for the plaintiff raised objection and submits that the defendant has received the writ of summons on 4th of June 2025, but has not shown any reason why the defendant has not filed the written statement within the period of 30 days. Though the defendant has taken the plea with regard to the old document, but the defendant has not disclosed the documents which are the old and was not traceable within the period of 30 days. He submitted as the defendant has not shown any cause for condoning the delay for acceptance of written statement and prayed for rejection of the present application. Had the learned counsel for the respective parties peruse the materials on record. The defendant in open court has handed over the copy of the written statement, which was affirmed on 6th of September 2025. Full stop. Counsel for the defendant has the defendant in the present application has categorically stated that after the receipt of the writ of summons, the defendant has took some time to trace out the document as the transaction between the plaintiff and the defendant was old one, due to which the defendant could not file the written statement within the period of 30 days. Though the defendant has not filed the written statement within a period of 30 days, but has filed the written statement within the outer period of 120 days, and as this court is of the view, one opportunity should be given to the defendant to file written statement, subject to payment of cost of ₹5,000 to the High Court Legal Service Authority within a week from date. The written statement filed by the defendant in court today is accepted, subject to scrutiny by the department. The defendant is directed to serve the copy of the written statement to the counsel for the plaintiff in course of the day. The defendant is directed to produce the evidence of showing the payment of cost as directed above to the London master within a week from date. GA numbers disclosed.
Grateful man.
Next.
I appear for the plaintiff in this matter. Now, this is the plaintiff before your lordship.
Right. Subject to scrutiny. Department of accepted over. Subject to scrutiny. Yes.
Yes, my lord. The plaintiff before your lordship is the resolution professional who has been appointed in respect of the plaintiff company. The suit has been filed through the resolution professional because the plaintiff has undergone corporate insolvency resolution process.
Correct.
My lord, the plaintiff had entered into a transaction for purchase of shares of the defendant. The plaintiff had remitted ₹10 crores to the defendant's bank account for the issuance of the shares. Those shares were never issued, and the consideration totally failed. So it's the suit for refund of that consideration paid. Now, my lord, I have the bank statements to show the remittance of that amount, and I also have the documents.
What is the suit for?
Suit is for recovery of money.
Recovery of money?
Yes, for refund of the money paid for allotment of the shares.
Allotment.
It's a money suit.
So
but in connection with the suit, I have come up with this interlocutory application praying for certain interim orders. Firstly, the defendant has admitted this amount by showing share application money received in its balance sheets, And that apart, my lord, a letter was written by the Economic Offences Wing to the defendant, to which the defendant has replied that they have this amount of rupees 10 crores received from us, kept apart, set apart. So, my lord, there is really, my lord, no defense to the fact that, my lord, the defendant has been paid this money, and, my lord, that the defendant was liable to issue the shares, but the shares have not been issued. So the defendant has, by its own showing, has stated that it has the money, which it is not issued any shares. So, my lord, by this application, my lord, all I seek today is, my lord, an injunction restraining the defendant's bank account from, my lord, without keeping apart that amount, and also that the defendant should not be disbursing any amount to any other authority. Because, my lord, as your lordship knows, my lord, once a CIRP is, I'm sorry, my lord, corporate insolvency resolution process, my kindly pardon me, is initiated, my lord, then your lordship, my lord, everything has to be before the NCLT, all the money has to come. Before the, my lord, resolution professional, the resolution plan is received and COC approved, the committee of creditors approves it, and, my lord, then, my lord, the amount is disbursed. So, my lord, this is one of the principal assets which, my lord, the corporate debtor, which is the plaintiff, has. This 10 crores of amount is one of the principal assets which it has, and it's an admitted amount. May I show from where, my lord, your lordship would get this? And, my lord, the plaintiff was a non-banking financial corporation. So we have annexed that certificate also. That is, my lord, Annexure A.
Once you are in the CIRP, how this court can entertain at this stage?
My lord, Section 25 permits, my lord, the resolution professional to, my lord, institute all proceedings, my lord, to get the money.
Correct.
So, my lord, it permits that, my lord, if your lordship kindly takes a look at the Insolvency and Bankruptcy Code, my lord, Section 25B, my lord. I'm sorry, my lord, 25 2B.
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 Present an act on behalf of the corporate debtor with third parties, exercise rights for the benefit of the corporate debtor in judicial, quasi-judicial, or arbitration proceedings. But we often see, my lord, arbitration proceedings being carried out by the, my lord, corporate debtor through the resolution profession. But the counterclaims are not permissible. That is the bad thing about this law, my lord. But, my lord, if I may draw your lordship's kind attention, my lord, firstly, my lord, to, my lord, the order, my lord, page 24, I need not trouble your lordship with this, my lord. Page 24, the order starts. This is the, my lord, initiation of the corporate insolvency resolution process, my lord. Your lordship would kindly have a look at, my lord, page 38, where the initiation of corporate insolvency resolution process has been ordered. Page 38, my lord, paragraph 6. And here, my lord, your lordship would find at subparagraph small Roman 6 that the resolution professional has been appointed. That is at page 39, bottom, my lord, last paragraph at page 39. Your lordship would find the name of Mr. Yogesh Gupta, who has filed the suit on behalf of the corporate debtor as the resolution professional.
Yes, then.
Now, my lord, the bank transfers, which your lordship would find from page 44 onwards, my lord, I have annexed the bank statements of the plaintiff, my lord, showing the bank transfers. My lord, your lordship need not labor into finding these because, my lord, I shall show from the defendant's own admission that they have, my lord, accepted this. My lord, firstly, my lord, from the defendant's, my lord, audit, from the plaintiff's audit report, and thereafter I shall show from the defendant's audit. My lord, kindly sees from page 80. At, my lord, page 86.
Yes. Yes.
Where, my lord, the plaintiff had shown, my lord, the share capital, page 86, my lord.
Yes. Long-term borrowing, current liabilities, short-term provision.
And, my lord, I shall show from the defendant's
No, what you want to so from the age 86?
Just give me a minute. Non-current investments under serial Roman 2 assets.
Non-current
Here,
assets.
it is in excess of crore. This amount forms part of that. Exact this the amount of 10 crores would form part of this amount of 11 crore odd. So this is one. And I shall also show from each of the entries in the bank statement. I shall also show that. Will kindly have a look at the bank statements once. Well, I should have shown that. I'm sorry. Kindly takes a look at the entry dated 25th of October 2017.
Page.
Find that at page 52. 57. Kindly sees 25th of October.
Page 57.
I'm sorry.
57.
57.
Page 57.
Yes, 57. Middle of the page.
পয়সা দিয়েছে তো
লাস্ট যেটাতে আমি পুট আপ দিয়েছি সেটার পয়সা নিয়ে বাকিটা সব করে দিয়েছি হয়নি অর্ডার
Shanti Kumar.
Your Lordship has seen the 25th October transferred to Regent Capital towards the middle of the page.
Middle of the page.
57.
57. 25th October. There are 4-5 entries. Kindly sees the fourth entry. The transaction number is 293590. 25th October, fourth entry. Fourth entry of 25th of October.
Regent's Capital.
Regent Capital, which is the defendant. That is the defendant.
10 crores.
So, that is the first one. Then second is, your Lordship would kindly have a look at the 2nd November 2017 entry, which will find at page 58, the second entry from top.
Yes.
Well, that is 2nd of November. Then the fourth tranches it was paid. The third one is dated 29th of December 2017, which my lord will find at page 62. Kindly sees the entry, about 10 entries from the bottom, my lord. Your Lordship would find Regent Capital against transaction number 309927.
Yes.
And the last one is on 16th of July 2018. That is the main chunk, 6.5 crores went. 16th of July 2018, which your Lordship would find at page
74.
74. Your Lordship would find at the middle of that page, the entries of 16 July are there. Towards in respect of the transaction number 339543, your Lordship would find 6.5 crores went.
$74.
74, your Lordship. Towards the middle of the page.
Yes.
There's a transaction with number 339543.
Yes. Next.
6.5 crore.
Yes.
So, 4 tranches, 1 crore, 1.5 crore, 1 crore, and 6.5. Total 10 crores transfer.
Yes, then?
Now, your Lordship would kindly have a look at page 100 of the application, where, my lord, the defendant had written to the Directorate of Economic Offences, admitting these payments.
admitting these payments. First, at the top, these 4 transactions have been admitted. Kindly sees total is 10 crore. Then kindly sees the paragraph after the table. We undertake to block the amount of rupees 10 crores with accruals, if any, as invested by us out of the above receipts, and further undertake to comply with the related provisions of the such and such depositor. So this is an admitted position.
Yes.
Then we will kindly have a look at page 102, which is the auditor's report of the defendant. I need not labor into this, but still, since we have annex, kindly takes a look at this also to show from their books of accounts also that they have received this.
Which page?
Mr. Bandapathy would please indicate page 112 is the balance sheet. This is in 1000. So your lordship would find current liabilities. This is them. For this reason, the resolution professional had thought it fit to annex. Though the exact amount is not there, but in the reserves and surplus, in the current liabilities, they are reflecting this.
Current liability, they are shown only 2 crore and 2,06,000.
No, this is in 1000. Your lordship would see top right. This amount is in 1000. So this is really 2 crore 6 lakhs 975,000. The amount isn't reflected in 1000. The lordship would find that at top right corner of the page 112.
Okay.
It's in 1000.
Okay.
But initially, I was also rebuking Mr. Bandapathy that this is not tallying. Then we found out together. So today, all we want is that this amount be kept aside and not be remitted to any other account, because your lordship would kindly have a look at my press. But in aid of my money claim, this is my interlocutory relief which I am claiming as of. And we have
yes.
And we have filed this suit after a non-starter report. So in the mediation also, they did not come forward. It was a non-starter. But when we have wanted to serve this application and the affidavit of service is already on record, your lordship, they say that they have left. But we have been able to serve them by email.
They are appearing?
No, they are not appearing. Kindly seize the affidavit of service also, and I should indicate that before I press for any order. Kindly seize page 8. I have already served by email, and that has never come back. It is not bounced. But the service which we have sought to effect by postal receipt, there is no tracking report of that yet.
So you are moving ad interim?
No, I am moving ad interim, but not expert. I'm praying for ad interim order, but now kindly seize my prayers.
So notice served, not served.
We have served page 8 of the affidavit of service. We have served by email the application and the notice of motion. Your lordship would find 2 PDFs are there at the bottom of that page, bottom left, page 8 of the affidavit of service.
Yes.
Before the mediation also, we tried to have it sorted because they have already admitted this amount. They are keeping it apart on account of the plaintiff. Yet there have been no response from their end. So here what we have claimed really is this amount including the interest, because your lordship would find the interest is paragraph 24 where we have made the calculation at page 14 going on to page 15. But to be candid to your lordship, my lord, I really cannot press for the amount including the interest at this stage.
Only you
So-
will get 10 crore.
Only 10, yes. That is my claim in the suit. If and when I ultimately succeed, then your lordship would consider, my lord.
Yes. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 20,83,61,250 along with interim interest and interest upon judgment at the rate of 15% per annum. The plaintiff has filed the present application being GACOM 1 of 2025, praying for interim order. The plaintiff has sent the notice of the present application to the defendant through mail, which was duly served upon the defendant on 1st of September 2025, but none appeared on behalf of the defendant. The plaintiff says that
Well, I have pleaded that in paragraph 3 of my application, my lord.
that
Your lordship kindly takes a look
as
at
per the
paragraph 2.
As per the request of, as per the representation of that one of the director of the defendant, the petitioner has invested an amount of rupees 10 crore for purchase of shares from time to time. And accordingly, the defendant has admitted that the defendant has paid an amount of rupees 10 crore for purchase of share. Full stop. After the receipt of the said amount, the defendant failed to give the share to you. What is your case?
Yes, my lord. The no shares were allotted, so consideration failed.
Shares have been allotted to the plaintiff. Accordingly, the plaintiff has sent a notice to the defendant for return of the said amount, but the defendant has neither given any share to the tune for a sum of rupees 10 crore, nor the amount of rupees 10 crore or interest accrued therein has been returned to the plaintiff. Full stop. Counsel for the plaintiff submitted the plaintiff is under CIRP and the plaintiff has filed the present application through the insolvency resolution professional appointed by the tribunal. Insolvency resolution professional appointed by the tribunal. Okay. Counsel for the plaintiff and the Mr. Gupta, then advocate appearing for the plaintiff submits that the defendant has admitted the claim of the plaintiff that the plaintiff has made the payment of rupees 10 crore for purchase of the share, but the defendant has not given any share to the said amount or has returned the said amount. Now the plaintiff came to know that the defendant is going to siphoning off the amount of the plaintiff. He submits that if at this stage the defendant is not restrained from invest any amount by keeping aside an amount of rupees 10 crore, the plaintiff will be badly penalized. And will be badly penalized. Mr. Gupta submits that the defendant by a letter dated
Page 100.
Page 100, your lordship.
Yeah. Page
Page
number
100.
Page 100.
July 11, 2022.
The letter dated 11th of July 2022 has admitted that the plaintiff has paid the amount of rupees 10 crore, but in spite of the same, the defendant has not paid the said amount, returned the said amount to the plaintiff. at the landed council for the plaintiff produce the materials on record. This court find that by an order dated, this court find that by an order dated 7th April 2025, the NCLT has appointed a resolution professional in respect of the company of the plaintiff. The plaintiff has disclosed the bank accounts wherein it shows that the plaintiff has transferred an amount from time to time in the name of the defendant for purchase of share for a total amount of rupees 10 crore. Full stop. The defendant by a letter dated 11th of July 2022 has also admitted that the defendant has received the amount of rupees 10 crore. The plaintiff has also disclosed the audit report of the defendant, including the balance sheet, wherein it reveals that the other liabilities of the defendant company is shown as 20 crore 6 lakhs and 2 comma, this is 20 crore or 206. What is the, it is 1000 in 1000, no?
Yes, this is in 1000.
1000. It is 20.
No, not that
About rupees 20 crore. About more than 20 crore. About more than 20 crore. ठीक है? Considering the above, this court find that the plaintiff has proved that the plaintiff has transferred an amount of rupees 10 crore in the account of the defendant for purchase of the shares.
But only one thing, Your Lordship, would kindly have a look at page 100. Kindly sees the top before the table. They have admitted that this is for the share 5 lakh shares. 5 lakh shares.
By a letter dated 11th of July 2022, the defendant has also admitted that the defendant has received an amount of 10 crore for issuance of 5 lakh equity share to the plaintiff. Full stop. To the plaintiff. Full stop. From the balance sheet also find that the liability of the defendant is about more than 20 crores. Full stop. The plaintiff in the present application has categorically stated that where is the averment
with regard to election,
interim order.
Oh, I'm sorry. Kindly takes a look at.
And categorically stated that the plaintiff came to know that
Page 17 onwards.
the defendant is defrauding the plaintiff and other creditors by transferring or alienating or encumbering its assets to the third parties. It is also alleged, it is also made an averment that the plaintiff has also made a specific averment that the defendant is threatening and intending to remove or dispose of the properties. Considering the above, this court find that the plaintiff has made out a FSA case by balance of convenience and inconvenience in favor of the plaintiff. This court also find that if at this stage an identity model is not granted, the plaintiff will suffer irreparable loss and injury. This could also find that the defendant has admitted the claim of rupees 10 crore received by the defendant from the plaintiff, but it is also received by the defendant. And if at this stage an identity model is not granted, in future if the plaintiff will get a decree, the decree will be frustrated. will be frustrated. Accordingly, the dependent is restrained from dependent, it man servant assigns are restrained from operating the bank account current bank account number 0006050177796 maintained with the ICICI Bank Limited, RN Mukherjee Road, Kolkata, by keeping aside an amount of rupees 10 crore till 11th of November 2025. The plaintiff is directed to serve the notice along with serve the copy of the application documents and obtained to the defendant immediately and to file the affidavit of service on the returnable date.
Serve the order also. Serve the order.
Along with this order. Let the matter appear on 11th November under the heading new motion. Next.
Obligement.
APA for the plaintiff, my lord. My application for judgment upon admission, my lord. Your lordship will recall, my lord, this was under section 22 of the Hindu Succession Act, my lord. Nephew and aunt and the nephew, my lord. Nephew has sold off the property to a third person, my lord, without permitting the aunt to exercise the right of, my lord, preemption. So, Mr. Mola was argued, my lord, in the written statement, my lord, they have said that they have not given us any option to buy it before that.
My lord, I was supposed to give a response to this, but I say, my lord, Order 12, Rule 6 doesn't apply. My lord takes up their Order 12, Rule 6 application for once.
Yes.
Kindly takes up from, my lord, paragraph 10.
Yes.
Lord, why I take it from paragraph 10 before placing paragraph 10 onwards, my lord?
10 of application?
Yes, of the application.
Yes.
My lord, he pleads law from paragraph 10 onwards. Now, my lord, what he says in from paragraph 10 onwards is, my lord, the case falls under section 22(1), 22 of the Hindu Succession Act and section 44 of the Transfer of Property Act. Now, my lord, if my lord takes up, my lord, section 22 of the Hindu Succession Act for once, my lord, then I take your lordship whether in this gamut, my lord, a judgment upon admission can be passed. My lord, the fact remains, my lord, a transfer has occurred. Now, my lord, 22(1) says is a stage where the transfer is yet to be made. So, my lord, at that stage, 22(1) come into play and 22(2) comes into play.
Okay.
My lord, kindly takes up
Section 22.
22 of the Hindu Succession Act.
Yes.
Yes. Let me just place it. Where after the commencement of this act, an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon 2 or more heirs specified in class 1 of the schedule, and any one of such heir proposes to transfer his or her interest in the property or business, the other heirs shall have a preferential right to acquire the interest proposed to be transferred. So, my lord, is at the proposal stage. Who is preempting, my lord? Preempting is, my lord, the class 1 heir. So, my lord, in our case, my lord, a transfer has occurred. It has crossed the proposal stage. Now, my lord, kindly takes it to subsection 2. The consideration for which any interest in the property of the deceased may be transferred under this section shall, in the absence of any agreement between the parties, be determined by the court on application being made to it in this behalf. And if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all cost of or incident to the application. So, my lord, 22 envisages an application at the proposal stage. Now, my lord, we have crossed the proposal stage. My lord, it's a regular suit which has been filed. Now, regular suit, my lord, has been filed, my lord, to enforce the right to see whether I have violated 22(1) or not. Now, my lord, in my respectful humble submission, for inquiry to this purpose, it requires adjudication, because they have to satisfy there is a violation of the condition of 22(1). Now, my lord, first, my lord, who is coming up before this court? My lord, kindly takes up the plaint. Plaintiff copy.
Yes.
My lord, plaint is and it's page also. If my lord takes up the plaint, 27, my lord.
Who are you?
My lord, I am not the class 1 here. This is my question. Now, my lord, kindly seize the plaint. If my lord sees the plaint, my lord, Subroto Sarkar.
Yes.
Is the daughter of Vidyut Bikash Basu and Anima Basu. They are the original owners. Now, my lord, Vidyut Bikash Basu and Anima Basu had 2 daughters, Shutopa and Shubroto. Now, my lord, both of are married daughters. So, my lord, Shubroto Sarkar is the, my lord, other daughter. Shutopa.
No, Subroto is the wife of Subroto is the daughter of
Vidyut Bikash Basu and Anima Basu.
The land belongs to whom?
Vidyut Basu and Anima Basu. Original
land belongs on origin. Who was the owner of the property?
Vidyut Bikash Basu and Anima Basu are the original owners.
Joint owner.
Joint owners. They are the husband wife. Or the Vidyut father. Father and mother.
Vidyut Bikash
Basu and Anima Basu.
Lord, I filed a list of dates, my lord. It might be convenient to your lordship.
My lord, for the moment, list of date is not required, because this is, my lord, on the provisions of law. Because, my lord, admission, my lord, there cannot be admission as to law.
On the facts only, my lord. It should be only.
Yes.
Well, I can
Now,
give
my
a
lord,
copy, my lord.
they are the original owners.
Now, my lord, on the death of both of them, my lord, they leave behind 2 daughters, Shutopa and Subroto Sarkar, the plaintiff.
Sutapa.
Yes.
Subroto.
Subroto. Now, my lord, Shutopa died on 4th of September 2020, leaving behind her husband, Satyonarayan Ghosh.
Died on?
Died on 4th of September 2020.
Yes.
Leaving behind her husband, Satyonarayan Ghosh, and son, Supriyo Ghosh.
Satyanarayana husband.
Satyonarayan husband.
And Supriyo?
And Supriyo Ghosh.
Different number 1.
Yes. No.
Different number 2.
Different number 2, Supriyo Ghosh. So, my lord, after the death of Shutopa, my lord, her 50% devolved upon the husband and the son. So, my lord, today, Supriyo Ghosh in factual matrix of this case has been because Satyanaran Ghosh died in the meantime. Father of Supriyo Ghosh died. Now, my lord, Satyanaran Ghosh therefore becomes, my lord, the absolute owner of the 50% share of Sutopa. Now, my lord, the moot question under section 22(1) is, my lord, the parties between the intestate, my lord, who is transferring, my lord, devolving, has to be in class 1 heir. So, my lord, Subroto is not class 1 heir of Supriyo, because Supriyo is transferring. Supriyo Ghosh has transferred it to the defendant number 1, Surojit Mitra. If my lord reads the provision, it says, where after commencement of this act, an interest in any immovable property of an intestate or in any business carried on by him. So, intestate here is, my lord, Sutopa. So, Sutopa being intestate, my lord, his property devolved upon Satyanaran and Supriyo. So, my lord, had it been a case, Satyanaran is alive and Supriyo is transferring, Satyanaran and Supriyo being in class 1 heirs, one could have injuncted the other. Whereas Subroto, my lord, is not the class 1 heir.
But the actually the Vidyut and Anima.
Yes.
Correct. So both died.
Both died.
Leaving behind 2 daughters.
2 daughters.
So this has been segregated, separated with the Sutapa and Subroto.
I couldn't follow, my lord.
Because the property belongs to
Vidyut and Anima.
Vidyut and Anima.
Yes.
They died leaving behind 2 daughters.
2 daughters.
Sutapa and Subroto.
So 2 daughters are class 1 heirs.
Correct. Both are the class
1 heirs.
So if they are the class 1 heir, and both will get the 50 share each.
Each.
Correct.
Absolutely, my lord.
Will get the 50 share.
Absolutely, my lord.
So whether now the Sutapa get 50%, Subroto get
50%. Absolutely correct.
Correct.
Absolutely.
So now this the deed which is under challenge of which of the total property of the 50%.
No, 50%. 50% which Supriyo has.
Whether it was partition?
No, my lord, it is not partition. So, my lord, Supriyo has 50%.
Correct.
So, my lord, now the question is, my lord, whether Subroto and Supriyo are in class 1 heirs. Because the language is of the provision, if my lord takes the provision once again, where after commencement of this act, an interest in any immovable property of an intestate.
Correct.
So, my lord, who is intestate here? Sutopa. Sutopa has died. So, from Sutopa, the property devolved upon the husband and the son.
Correct.
So, my lord, or any business carried on by him or her, whether solely of or in conjoined with others, devolves upon 2 or more heirs specified in class 1 of the schedule. So, my lord, today if Supriyo sells, Subroto cannot be the class 1 heirs because she is the aunt of Supriyo.
No, but the property belongs to the after the Vidyut, Sutapa and
My lord, had it been a case, that Sutopa was selling.
So you have come third stage now.
Yes.
The first stage you have to clear. After the Vidyut and Anima.
Yes.
Sutapa and Subroto both having their class 1 heirs.
Yes. Sutapa, Subroto is class 1 heirs.
Class 1 heirs.
There is no doubt.
And Sutapa died.
Sutapa died.
Sutapa died. You are telling that the 50% Supriyo has transferred to the plaintiff.
No, defendant number 1.
Sorry, defendant number 1.
Yes.
So you are telling that he is not the class 1 heir and he sold his 50%. So the 22 will not affect.
22 will not affect.
Correct. So, but with regard to how this partition has been occurred.
Now, my lord, now coming to my lord. Now, my lord, the law is very settled, my lord, that a co-owner can sell his share. Now, my lord, to the extent of the law that whether I can sell my share or not, there is no embargo or doubt. My lord, I have a right to sell. My lord, if I have a right to sell, the law also enjoys with certain liabilities. My lord, if I sell to an outsider, my lord, 2 things come into play. First is, my lord, whether the outstranger can have a joint possession in the property or not. And second is, the other co-sharer, whether they can enjoy the right of preemption under 22. Now, my lord, to the 22, my lord, I say, as Subroto and Supriyo, they do not fall in class 1 heirs. So, my lord, the 22, my lord, doesn't apply in this case.
Why you are telling that Subrata is not coming under the...
My lord, kindly takes the schedule of succession, schedule 1. Aunt doesn't fall in class 1. Subrata is aunt of Supriyo.
Class 1 of the original owner.
No,
Not
then,
the...
no, my lord, that's not the provision of 22. My lord, the intestate, my lord, it cannot happen that
You read it. Where the commencement of this act and interest in any immovable property and intestate or any business carried on by him on her, whether solely or in conjunction with other, devolve upon 2 or more heirs specified in class 1.
Yes.
So, which property is to devolve?
Absolutely, my lord, kindly pause here for a moment. My lord, the property, when initially Anima and Biddut died, my lord, it devolved. So, my lord, there, 2 daughters, class 1.
Correct.
Now, situation had it been case at that point of time, Shutova was selling or Subrata was selling, both being in class 1, it qualifies the provision. But since Shutopa did not sell anything, and after her death being intestate, the property further devolved. So, my lord has now to look into, my lord, this devolution, not the previous devolution.
So your question, your submission is that the 50% which come to the Sutapa, now it has come to the Superior. Superior is not the legal class 1 here of the Subroto.
Yes.
So this 22 will not lie.
Yes.
This is your case.
This is my case.
Okay.
So, my lord, by virtue of this, my lord, 22, my lord, I do not, my lord, qualify the ingredients. My lord, for this, my lord, even for this, my lord, there requires an adjudication. Now, my lord, secondly, my lord, 44, my lord, the point which has been taken. My lord, I have very simple submission to this. My lord, kindly take section 44 of the, my lord, Transfer of Property Act.
Yes.
Where one of 2 or more co-owners of immovable property legally competent in that behalf transfers his share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to condition and liabilities affecting at the date of transfer the share or interest so transferred. So, my lord, first part of this says, my lord, a co-sharer can sell to a third party stranger, but my lord, to have joint possession, he has to effect partition.
Correct.
Now, my lord, second part, where the transferee of a share of a dwelling house, my lord, this is a dwelling house, this case is a portion of a dwelling house has been said. Where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the house. Now, my lord, simpliciter saying, my lord, I am in a dwelling house doesn't make the house to be a dwelling house. My lord, he has to satisfy the condition, my lord, that it is a dwelling house with a absolute privacy. No other than the family members are in the property. Now, my lord, to this extent, my lord, there is no pleading in the plan. I could not find 7 except saying it's a dwelling house. So, my lord, to this satisfaction of condition, my learned senior friend would definitely point out, my lord, I have perused through the plan. I do not find these conditions being pleaded.
Yes.
Now, secondly, my lord,
yes.
Now, secondly, my lord, kindly takes up, my lord, there was a, my lord, receiver appointed in this suit. My lord, kindly takes up the receiver's report.
It is disclosed here.
My lord, it is filed before the court, my lord. আচ্ছা, তোর কাছে extra copy আছে? No, this is an extra copy, my lord. I'm just turning on the page, my lord. My lord, kindly takes up the directly to the point, my lord. My lord, the entire premises was inspected. There is no challenge as of date to this, my lord, by the plaintiff. My lord, kindly sees the ground floor. The ground floor of the said premises consists of 7 rooms, 2 bathrooms. The rooms at the southeastern corner of the said premises was used as an advocate's chamber by late Bidut Vikas Basu, the deceased father of the plaintiff. It is continued to be used as advocate's chamber by one Aurobindo Dotto, advocate, who was a junior of late Bidut Kumar Basu. I'll stop here for a moment. My lord, then, my lord, a stranger, my lord, is in the property. My lord, whether he is a tenant, whether he is a licensee, gratuitous licensee.
Yes.
So, my lord, the dwelling house has lost its character of a dwelling house. So, my lord, if this is, my lord, coming before this court today, and my lord, where the plaintiff is briefed of any of the conditions being pleaded,
yes,
then, my lord, in my respectful humble submission, my lord, the order 12 rule 6 cannot apply, because this is something on law, and my lord, this requires adjudication whether the law will apply or not. Now, my lord, kindly takes up the plaint once again. My lord, kindly takes up the pleading, what he has pleaded in the plaint. My lord, kindly takes up paragraph 10 of the plaint.
Yes.
Well, I am placing paragraph 10. Thus, on the demise of Shutopa Ghosh and Shottyanarayan Ghosh, the plaintiff, along with the defendant number 2, became joint owners of the said residential premises dwelling house, having joint ownership and possession. The property was mutated in the joint names of the plaintiff and the defendant number 2 with Kolkata Municipal Corporation as the co-owners thereof. A copy of mutation certificate.
One page is missing.
Miller, one page is blank. Thereafter, internal page. Miller, was found. Miller, paragraph 10, thereafter, one page is blank. Turns over, Miller. Page blank.
No, here there is no page at all.
But it is
After
there,
the 10th paragraph 14, it is page.
Well, kindly takes up this copy. Well, probably inadvertent mistake has occurred in the application.
Yeah, that is not.
Now, my lord, the property was mutated in the joint names of the plaintiff and the defendant number 2 with the Kolkata Municipal Corporation as the co-owners thereof. A copy of such and such is annexed. Plaintiff states that plaintiff has been paying ongoing taxes in respect of the premises since death of Anima Basu, the mother of the plaintiff. The plaintiff is also paying all expenses for the maintenance of this and also paying the salary of the staff of the premises. The said staffs are old staff and they used to work for the original owners of these premises, being the late father and late mother of the plaintiff. Since the beginning of the year 2023, defendant number 2 approached the plaintiff with a request to agree to sell the premises as a whole, as he was facing financial difficulties. It is pertinent to mention that the defendant number 2, who is presently aged about 47 years, is unemployed and is dependent upon the funds inherited from his parents. Dr. Shottyanarayan Ghosh, since deceased, was an ENT specialist in government service attached to the government hospitals. He retired from Bosirhat Government Hospital. On his retirement, he was doing independent practice at Bosirhat. He had his residence at Bosirhat being a rented property, but he also came with his son, the defendant number 2 herein, to reside at the joint residential property within the suit premises. In the month of April 2023, the defendant number 2 approached the plaintiff and suggested that the plaintiff should agree to sell the property jointly to one Surojit Mitro. The defendant number 1 hearing. The plaintiff, considering the plight of the defendant number 2, had agreed to meet the proposed buyer to discuss the price. Accordingly, a meeting was scheduled at the office of the plaintiff situated at 10A Ho Chi Minh Saroni, Kolkata 71. The said meeting was, however, attended by defendant number 2 along with broker Mr. Indranil. The alleged prospective purchaser Surojit Mitro, the defendant number 1, however, did not attend the said meeting. At the meeting, the broker expressed his helplessness to commit a price. The negotiation thus did not progress. The plaintiff states that the negotiation thereafter did not progress any further. Suddenly, around first week of August 2023, the defendant number 2 approached the plaintiff and suggested that the negotiation between the said proposed buyer and the plaintiff and defendant number 2 be tried once again. The plaintiff, however, was surprised to receive a draft copy of the agreement for sale through an email dated such and such by one Mr. Deval Dash, advocate having email address such and such, to the plaintiff's email address being Subroto Shasanchar. The said Deval Dash claimed himself to be the advocate of defendant number 1. A copy of the said mail dated such and such along with draft copies annexed. A bare perusal of the said agreement would show that all material particulars as required under an agreement was kept blank, including the consideration thereof. The plaintiff said that since month of August 2020, neither the defendant number 1 nor the defendant number 2 contacted the plaintiff, and in fact, defendant number 2 stopped communicating with the plaintiff. The plaintiff, however, continued to occupy and enjoy the property and paid the entire outgoing in respect of the suit premises, including up-to-date municipal tax thereof, considering the financial difficulty of the defendant number 2. Since neither the defendant number 2 nor the defendant number 1 contacted the plaintiff thereafter, the matter remained standstill. In the absence of a price being offered, no further step could be taken by the plaintiff, and consequentially the negotiation failed. The plaintiff said that since the negotiation failed due to the inability of the defendant number 1 to commit to either an agreed consideration or for fixing a date of execution and registration of the conveyance, and to show his capability to pay for the consideration for purchase of the premises, the negotiation remained a non-starter. None of the defendants had any further communication on the subject with the plaintiff. The plaintiff states that on 5th December 20 at about such and such received a message in her mobile number such as for Department of Kolkata Municipal Corporation to the following. I am not reading without mutation with regard to mutation. The plaintiff, being surprised to receive said message, immediately contacted her lawyer, and who, upon making necessary searches and checking the website of Kolkata Municipal Corporation, came to know that the name of the defendant number 2 has been deleted and the name of the defendant number 2 has been included as co-sharer of the suit premises in the records of Kolkata Municipal Corporation. The plaintiff was surprised to note that such change in the record of Kolkata Municipal Corporation, which happened without notice of the plaintiff and without any intimation being sent to the plaintiff, either as regards mutation application having been filed by the defendant number 1 or any hearing of the case being taken place. A copy of such and such is annexed. Plaintiff states that thereafter no further probe being made by a learned advocate in on further probe being made by a learned official website of West Bengal Director of Registration and Stamp Revenue, it transpired that the deed of conveyance was registered on 21st day of August 2023. On coming to know of the said fact, plaintiff applied for certified copy. But thereafter, the deed has been, I'm not troubling. Now, 28. Plaintiff stated that a perusal of the deed of conveyance revealed the defendant number 2 had executed the said deed of conveyance in favor of the defendant number 1 on such and such, and had conveyed his undivided 50% share in the suit premises for consideration of such and such, as would appear from the memo of consideration. It appears from the inquiry slip appended to the said conveyance that market value is assessed at rupees such and such. Now, I'm skipping over. Paragraph 30 directly comes into. The plaintiff states the deed of conveyance is executed and registered in the month of August. The possession of the dwelling house continues to be enjoyed by the plaintiff and defendant number 2. The property being a joint property, the defendant number 1 is not entitled in law of joint possession or enjoyment of house. The plaintiff states the defendant number 1 is not a member of family. The defendant number 2, being a member of family, has transferred a share of dwelling house belonging to an undivided family to defendant number 1, who is not a member of the family. The said defendant number 1 thus is not entitled to joint possession nor is entitled to other common or part enjoyment of the house. The plaintiff said defendant number 1 not being a joint possession, plaintiff is thus entitled to permanent injunction restraining defendant number 1 for claiming joint possession of the suit premises or other common part of the enjoyment of dwelling house. Plaintiff states that defendant number 2 has sold his undivided share.
You are appearing for both?
No, only one. Of the dwelling house illegally to a non-member of the family. Before effecting such sale, the defendant number 2 ought to have offered his share to the plaintiff first, at the value of which he was willing to transfer the share of the defendant number 1. The defendant number 2, not having undertaken the said exercise, the sale in favor of the defendant number 1 by the defendant number 2 is void ab initio, illegal, unsustainable. The plaintiff states that in alternative, plaintiff is entitled to a decree directing the defendant number 1 to sell, transfer, and relinquish his interest in suit in favor of the plaintiff for a consideration of the deed. Plaintiff states that in any event, defendant number 1 is not entitled to seek joint possession. I'm repeating, my lord, these are all repetition. Then, my lord, kindly turns to, my lord, the prayers. So, my lord, from this paragraph 10 onwards, my lord, I could not find a single averment, my lord, at least, my lord, to make out his case that Supriyo and Subroto are class 1 heirs. They are joint owners, no doubt. And under law, my lord, my learned friend is much senior to me. We have learned from them, my lord. They cannot be under class 1. Under no circumstances. The pleading of class 1, my lord, comes in, my lord, order 12, rule 6.
You are comparing the class 1 of from where?
From the deceased intestate. My lord, who is the deceased here? Shutopa. My lord, her forefathers, my lord, if I take back generation, my lord, suppose the property belongs to 5 generations back, then always there will be the first legal heirs will be the class 1. So, my lord, if the 5th generation transfers, my lord, 5th generation cannot be the class 1 of the 3rd generation. My lord, law is, my lord, not to that extent.
Okay.
Because it is from the intestate. So, my lord, class 1 of Shutopa, not class 1 of Onima and my lord Biddut. So, my lord, they are not in class 1. And my lord, secondly, my lord, from the plain reading of the plain, it is apparent that prior to sale, my lord, she was aware a sale is going to happen. So, my lord, at the proposal stage, my lord, even in one of the paragraphs, she says the other person ought to have offered me. My lord, she knew what is happening there. So, my lord, she has not exercised the right, my lord, of 22(1), which is not a suit, but an application. Before the court, look, this is happening, this is a stage of a proposal, I want to purchase it. So, because agreement has been exchanged through email. Now, my lord, at this stage, my lord, she chooses not to exercise the right. My lord, I have a case, my lord, of a defense that there is a waiver. Because you waited, despite, had it been a case, all of a sudden she came to know there is a transfer. My lord, I could have understood she has come in a suit saying that the provisions of 22(1) has not been followed. So, therefore, kindly set aside the sale. My lord, here is a case she was aware of the proposal stage. So, my lord, now the question would fall at the time of adjudication, and because that would require an evidence. My lord, as to, my lord, she was aware of the figures being settled out. So, my lord, if figures being settled out, my lord, this is a part of evidence. This is not in pleading, cannot be decided, my lord, mere by an application under order 12 rule 6 that requires an evidence.
Okay.
So, my lord, at this juncture, my lord, with this pleading, my lord, the order 12 rule 6 cannot, from prima facie of the plaintiff case. My lord, my admission, my written statement also says the same thing. That's why he has said, my lord, I also pleaded same thing. My lord, it was offered to Shubroto. I was purchasing from him. Thereafter, the sale has occurred. I have sent the agreement for sale in his email ID. The same arguments are there. So, even in this factual backdrop, my lord, I say, my lord, 22 doesn't apply. Now, my lord, I would be referring. My lord, decision of our High Court on 22, my lord. Sorry. Well, kindly takes up, my lord, 2008, volume 4, CHN, page 20. My lord, this is on the point. 2008, volume 4, CHN, page 20. My lord, this is on the point that when 22 applies, and my lord, what are to be looked into?
Yes.
My lord, kindly takes up paragraph 6 of the judgment. As far as, my lord, got it, my lord? As far as the prayer for preemption was concerned, the learned trial judge held that the relief in terms of section 22 of the Hindu Succession Act could be obtained by filing a regular suit after payment of ad valorem court fees and giving specific valuation of the property. It was further held that no evidence was adduced showing the price at which the property was sold by the mother of the party along with Bharati to the third parties. It was further pointed out that even no prayer for assessment of the consideration amount was made. Then, my lord, paragraph 10. My lord, I am referring to the submission of Mr. Roy Choudhury, my lord. According to Mr. Roy Choudhury, section 22 of the Hindu Succession Act gives an additional right of preemption in favor of a person, apart from the right of preemption conferred under section 4 of the Partition Act. Mr. Roy Chaudhary contends that all that is necessary for getting a relief under Section 22 of the Hindu Succession Act is that an undivided share in the immovable property or business carried on by an intestate either solely or in conjunction with other must be transferred by any of the heirs of class 1, and the application must also be an heir of class 1. Milord, here I am. So Milord, transfer has to be by class 1. So Milord, Shupro is never class 1 of Shubroto. Neither Shubroto is class 1 of Shupriyo. So Milord, transferor has to be in class 1.
Yes.
Mr. Roy Chaudhary further submits that his client has complied with such requirements of Section 20. Therefore, the learned trial judge erred in law in holding that the relief or preemption could not be granted in the present suit for partition. Mr. Roy therefore prays for modification of the decree passed by learned trial judge by granting decree for preemption in his favor. Then Milord kindly turns to Milord 13. Milord, the provision is quoted. I am not troubling. Kindly, I am placing 14. After hearing the learned counsel for the parties and after going through the provisions quoted above, we find that the aforesaid provision of this Act has conferred an additional right of preemption otherwise than the ones provided in Section 4 of the Partition Act or in Section 8 of the West Bengal Land Reforms Act. Unlike the provisions contained in the Partition Act, here the right of preemption is not limited to the dwelling house belonging to an undivided family, but to an immovable property or business carried on by a Hindu dying intestate, either solely or in conjunction with others. However, such right is available only to the heirs specified in Class 1 of Schedule. The provision of Section 8 of the West Bengal Land Reforms Act is needless to mention is limited to the plot of land held by a Rayat as provided in the said Act, and specific manner of the enforcement of that right has been prescribed therein. As distinguishing feature of Section 22 of the Act is that whereas in the case of preemption provided in other statutes, the right to apply for preemption generally accrues only on registration of the deed of transfer, but in this provision, such right has been conferred upon the preemptor even before actual transfer. If any of the heirs of Class 1 proposes to transfer his undivided share, another peculiar element present is that here the value of the considered proposed transfer should be decided by the court unless otherwise agreed by the parties, that is the transferor and the preemptor. The first question that falls for determination before us is if the transfer has already taken place before filing of an application under Section 22(2) of the Act, whether the right of preemption conferred under the subsection 1 of 22 is lost. Our considerable view is that even if the transfer has taken place, the right of preemptor under this section is not lost. It is absurd to suggest that the right conferred upon an heir as provided in subsection 1 of Section 22 can be frustrated by merely completing the transfer without disclosing the intention of the transfer to the person who have the right of preemption. However, if in spite of disclosing the intention of transfer, the person who have the right of preemption decide to waive such right, the court in given situation can refuse to grant the relief of preemption, the right of preemption being a weak right. Milord, I am on here with regard to the other submission. Then Milord kindly turns over to Milord paragraph 19. 19. We further find that the legislature has not provided any right of appeal against, Milord, I am not, kindly skip paragraph 19, this is on appeal, whether appeal would lie or revision would lie. Not relevant, Milord. 20. The most vital question that next arises for determination is what will be the fate of preemptor if the transfer has already taken place. In our view, the subsection 1 of Section 22 having specifically provided that the other heirs shall have a preferential right to acquire the interest proposed to be transferred, such right cannot be destroyed by merely completing the transaction. However, if the transaction had already taken place, the purchaser acquires joint right in the property subject to the right of preemption of the other Class 1. In such a situation, the procedure prescribed under Section 22(2), which is meant for intended transfer, would not be applicable, and the preemptor would enforce his right of preemption, which is undoubtedly a civil right, by filing a civil suit as provided in Section 9 of the Code of Civil Procedure. Consequently, the Code of Civil Procedure will be guidelines for enforcing his right, including the right of appeal as provided in Section 96 or Section 100 thereof. Therefore, if a preemptor enforces his right after completion of transaction by a suit as provided in Section 9 of the Code, it must be done by presentation of a plaint as provided under Order 4, Rule 1 thereof. Such proceeding would take the shape of a suit for enforcing a right of preemption, and any decision passed thereon will be a subject right of appeal or second appeal as provided in the court. A right of preemption accrues either by statute or general usage or by special contract. Unless the statute conferring such right specifically lays down the manner of enforcement of such right, the same should be enforced in such manner all other ordinary civil suits are enforced as provided in section 9 of the code. Then, my lord, I would be referring to, my lord, there is one decision in paragraph number 22. This is being accepted by all courts, our High Court, Madras Court, Madhya Pradesh Court. This refers to AI 1976, Kerala 19, paragraph 22, my lord, we find. I just read the quoted portion of that judgment. AI 1976, Kerala, page 19. Thus, it will appear from provisions of section 22 that by subsection 1 a right is conferred, but there is nothing in that subsection to indicate what procedure is to be followed in the matter of enforcement of that right. Subsection 2 provides for a case where the parties fail to agree on the amount of consideration to be paid for transfer of the property, and it lays down the procedure for having the amount of consideration determined by the court on an application being made to it. Thus, under subsection 2, an application may be made to the court, but the scope of that application is quite limited. Such application may be made only for the purpose of determination of the amount of consideration, not for any purpose of enforcing the right conferred under subsection 1. In case where any statute creates a right without specifying the procedure for the enforcement right, the person intending to enforce such right shall have to resort to the procedures contained in the Code of Civil Procedure. For enforcement of his right, accordingly, the right conferred by section 22 can be enforced only by institution of a regular suit. It is significant to note in this connection that in case where a right is created by a special statute, generally a procedure is also prescribed thereby for the enforcement of such right. By way of illustration, mention may be made to the provisions of section 24 of the Bengal Non-Agricultural Tenancy Act, section 8 of the Land Reforms Act, and section 26F of the Bengal Tenancy Act. In all these cases, there is specific provision made for making an application when the right is sought to be enforced. But as already pointed out, subsection 1 of section 22 creates a right without specifying in special mode for enforcing the same. This view was also adopted by Kerala such and such. In the circumstances, it cannot be held that the original application under section 22 before the trial court was not maintainable. With great respect to the learned single judge, we are unable to approve his lordship's observation that subsection 2 of section 22 does not provide for enforcement of right under subsection 1, but meant only for determination of the amount of consideration. In our view, subsection 2 clearly provides for enforcement of right under subsection 1 if the transfer had not taken place. The determination of the amount of consideration money is for the purpose of enforcing such right, with further mandate that if the applicant refuses to purchase at the price so fixed, he would be liable to pay the cost of such application and same would be dismissed. If the transfer is complete, we agree with his lordship that a suit may be filed to enforce the right as is done by litigant for enforcing any other civil right. In case of such and such, the bench of Kerala High Court arrived at the conclusion that if the transfer had already taken place, a regular suit must be filed to enforce the right under section 22 of the Act, observed as follows. We are unable to agree with the contention advanced by the learned counsel for the appellant that the aforesaid question can be legitimately gone into by the court even in application filed under section 22 of the Act. In our opinion, the object of the legislature in enacting subsection 2 of section 22 is only to provide cheap and speedy remedy in cases where the property is in the hands of co-heir who proposes to transfer the same, and another co-heir is interested in acquiring the rights of the former, but the parties are not able to agree about the amount, about the consideration for which the former's interest in the property should be transferred to the latter. When the property itself had already been transferred by the co-heir, the first mentioned, we fail to see what useful purpose will be served by an investigation conducted by the court under subsection 2 for determining the price at which the property may be sold by the former to the latter. In such a case, investigation under subsection 2 may become irrelevant only after the person who feels aggrieved by the transfer effected by his co-heir in contravention of provision of subsection 1 has by resort to the appropriate legal process obtained a declaration from competent civil court that the sale effected by the co-heir in favor of stranger is invalid. Even in such a case, unless the co-heir who had effected the impugned alienation again proposes to transfer his interest in the property, there can be no occasion for any determination to be made by the court about the price payable by the other co-sharer under the subsection 2 of section 22. We are pausing here for a moment. So therefore, one of the prayer, my lord, I'll take to the prayer, my lord, is that please transfer it to me at the value. So, my lord, if defendant number 2 does not, my lord, come and say, again, I wish to propose to transfer, my lord, this has no manner of application, this provision, because sale has already affected. Decided cases dealing with section 22 of the Act appear to be few in number, and those which have been brought to our notice do not directly deal with the question that we are called upon to decide in this case. And hence, we do not consider it necessary to advert to them. In the light of what we have stated above, we are clearly of the view that the petition filed in court by the present appellant under section 22(2) of the Act was misconceived and was not maintainable. That the first respondent had already sold his interest in favor of the respondent number 2 to 4, and no steps have been taken by the petitioner in the manner contemplated by law for assertion and enforcement of a right under subsection 1. It has to be noticed in this connection that even though subsection 22(1) does not confer a right in the co-heir to acquire the share of another co-heir who proposes to transfer the share, there is nothing in the said section which warrants an alienation effected in the contravention of its provision being regarded as void. So, my lord, his prayer is that the sale is void. So, my lord, it's not void. Such an alienation will at best be only voidable at the instance of the sharer, who institutes the suit for enforcement of his right under subsection 1, and subject to the said limited contingency, the sale will be operative and binding. The lower court was perfectly right in holding that the prayers incorporated in the petition for declaration of invalidity of the sale effected by the first respondent in favor of the respondent number 2 to 4, and for a direction for the transfer of the first respondent share in favor of the petitioner as further relief consequential to such a declaration, are totally outside the scope of an application under section 22 of the Act, and we have no hesitation to uphold the said finding. We cannot, however, see our way to agree with the view expressed by the lower court that the proper remedy for the petitioner is to institute a suit for specific performance. Where there is no agreement, either contractual or statutory, for conveyance of the property, there can be no question of parties seeking the relief of specific performance. The remedy, as we have already indicated, is only to file a suit for enforcement of the limited right of purchase conferred by subsection 1 of 22. And in such a suit, the question of invalidity of sale already affected by the co-sharer will be incidentally investigated and decided. So, my lord, first, my lord, here is the question, whether there is a violation, whether you have a right under 22(1. If that be so, my lord, whether it has been violated. If that right you have waived or not, then incidentally, the sale will be invalidated, nothing more. Now, my lord, just 2 lines of 25, we substantially agree with the conclusion arrived by the division bench of Kerala High Court based, however, on the reasons assigned by us in this judgment, we however are unable to accept its view that a decree passed in such suit will not be appealable. So, only with regard to the question of appealability, this court has disagreed. Otherwise, my lord, other portions have been agreed upon. So, therefore, my lord, on this, my lord, my answer to this order 12 rule 6 is, my lord, under order 22 rule 6 today, my lord, seeing the pleadings and my lord being there, she being not being the class 1 heir of the my lord transferor, my lord, today they have no scope under 22(1). Now, my lord, formally, my lord, I am just handing over this Kerala judgment, my lord, I have relied upon. So, my lord, I am formally handing over. 76 Kerala. And my lord, I would rely upon another decision of Madhya Pradesh court.
Come on the next day.
Very well, my lord.
2007.
Nah, 1990.
Counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on. Give the date.
My lord, tomorrow and day after, thereafter, any day. My lord, my maternal uncle has expected.
24 November क्या time? 24 November 3:45 p.m.
24 November. Yeah.
Like May. It is reopening date too.
November.
May my learned friend repeat citation so Kerala এটা বলো
আমি বলে দিই I'll share.
Your lordship,
I can 19 my lord password.
No,
Password, nothing.
Your Lordship, kindly to mention item number
আমি আপনার
10
জুনিয়রকে বলে দিচ্ছি
today morning. The affidavit of assets were filed, but due to inadvertence of the advocate on record, we couldn't get a Xerox of the same. So can I just take it and take
Which one?
LMG shipping, item number 6 to 10 today morning. Affidavit of assets. So I need to take a photo of the affidavit.
My learned friend has come with instructions, my lord.
My lord, may I just take back the copy of the plane which we have handed and receiver's report.
My lord, I will request, my lord.
has come up and has been fixed by my lord pursuant to mentioning made on behalf of the plaintiff, my lord. Your lordship was pleased to pass an order on the 29th of July 2025.
Yes.
Fixing the matter for the day, my lord. My lord, the plaintiff is to be re-examined today. My lord, he was examined in chief. He was cross-examined. Thereafter, my lord, at the time of examination in chief of the defendant's witness, defendant number 4's witness, my lord, I'll give your lordship a short background. Defendant number 4 is the bank, Janata Bank, who has issued certain letters of credit in favor of my client, the plaintiff, who is an exporter of pulse. This export was made from India to Bangladesh. Defendant numbers 1 and 2 are the importers. My lord, after the export was made, when at the time the payment mode was through honoring of letters of credit. After the export of made was, my lord, this letter of credit was to be honored by the defendant number 4 bank, Janata Bank, the issuing bank. The importer is accepting the fact that the goods have been received by them. The Indian customs at the border, Indian territory border, my lord, they are saying, and they have documents which you have already disclosed.
Despite to the
Yes, my lord, they have said that the goods have also been transferred to the Bangladesh
customs
beyond Indian territory. Thereafter, what has happened, my lord, the Indian customs would not be having knowledge, but the importer is saying that they have received the goods. At the time when the LCs were to be, my lord, honored, this Bangladesh bank, Janata Bank, they are saying that there has been certain discrepancy with regard to the stamp of the customs, number one. And secondly, they have made out a new case during the course of their examination in chief of their witness that the importer and exporter has committed forgery and there has been defalcation of fund. This new case was not there anywhere in either in their pleadings or, my lord, otherwise from the documentation. So inasmuch as they made a new case, introduced a new case during their examination in chief, in order to counter that, my lord, we required to produce certain more documents. We made an application, formal application. It was heard at length. Thereafter, my lord, an order was passed by my lord, Mr. Justice Pattanayak, after lengthy hearing of both the parties, whereby he allowed, having considered that this was a new case made out by the defendant, he allowed us to produce these additional documents. Now, my lord, today your lordship has been pleased to fix this date. Yeah,
Speech.
Yes.
So, my lord, on the basis of this order that has been passed, my lord, your lordship has been pleased to observe that the witness will be examined on recall with regard to these additional documents. So, my lord, today is the day. And, my lord, the defendants, they chose that they would not inspect these documents. So, my lord, that is also recorded in your lordship's order dated 29th of July, 2025. So, my lord...
your witness is present?
Yes, my lord.
But who is for the other side?
My lord, yes. As has been recorded here in the order, last order, my lord, MS Shormishta Das, and at the time, my lord, when the deposition was being taken, Mr. Rupak Ghosh and Mr. Ayan Datta, they were the two counsel. My lord, this order was present in the presence of, passed in the presence of the other side.
Okay, let you examine. If they want to cross-examine, I'll fix the date for cross-examination.
As your lordship pleases. May the witness come. But these are the documents additional on the basis of which the examination is to be made today. You speak English?
এই কোর্টে আজকে প্রথমবার সাক্ষী দিচ্ছেন?
না এর আগেও দিয়েছি।
আপনার নাম?
তানভীর আহমেদ।
বানানটা বলবেন একটু।
TANVEER Ahmed.
Sorry,
Ahmed.
HMED, right?
MED.
Is the PW1 plaintiff?
Yes.
PW1
re-examined.
plaintiff is examined on recall. ठीक है?
You're going to 72 onwards. 72. My lord, may I take your lordship's leave to show this bunch to the witness? Oh, there, Mr. Doctor is here.
I am appearing on behalf of the defendant bank.
Your name has been brought to the notice of my lord. Your name has been brought to the notice in the sense you're appearing for the defendant. Yes. Witness, please have a look at the documents appearing at pages 2 to 19 of volume 1 of the additional judge's brief of documents.
2 থেকে 19
2 to 19 and tell my lord what these documents are about.
এই ডকুমেন্টগুলো দেখুন 2 থেকে 19 পাতাতে যে ডকুমেন্ট আছে এবং মাইলর্ডকে বলুন যে এই ডকুমেন্টগুলো কি ব্যাপারে।
ये documents exchange control copy.
These are the exchange control copies.
Exchange control copy within bracket GR forms.
These are the
Go slowly so that
exchange
goes down
control copy bracketed GR form number. Exchange GR form.
ये GR form RBI से issue होता है.
These GR forms are issued by the RBI.
RBI.
The Bank of India.
और इसी के तहत इसी के बिना पे एक्सपोर्ट मटेरियल एक्सपोर्ट किया जाता है.
By this document, the materials can be exported.
On the basis
of these documents, materials have been transported. Exported, sorry.
और ये डॉक्यूमेंट जो है इससे आरबीआई फॉरेन एक्सचेंज एज पर फॉरेन एक्सचेंज रूल फॉरेन एक्सचेंज कंट्रोल करता है.
सेंटेंस ठीक गया ना तो आपने क्या बोला?
इस जीआर फॉर्म के इस जीआर फॉर्म के वजह से फॉरेन एक्सचेंज आरबीआई कंट्रोल करता है.
Because of this GR form, the foreign exchange is controlled by the RBI.
इसके 2 कॉपी होते हैं. 2 कॉपी इन एसेट.
This document has 2 copies in a set.
पहला पेज.
The first page.
At the time of shipment, कस्टम वेरीफाई करता है मटेरियल कितना गया और फॉरेन एक्सचेंज कितना गया.
At the time of shipment, the first copy is examined by the customs to determine how much material has been exported, right?
And amount of foreign exchange.
And the amount of foreign exchange.
Determine and verify. We said verify.
The customs determined and verified with regard to amount of the foreign exchange with respect of the goods transported to the foreign exported to the outer country or abroad.
और अब कस्टम ऑफिसर एट द टाइम ऑफ एक्सपोर्ट जो कस्टम ऑफिसर होता है उस पे इंडोर्स करके साइन करता है.
And at the time of export, the custom officer takes this document and make his signature on this document.
उस पे काउंटर सिग्नेचर मेरा भी है.
On the said document, there is a counter signature of mine also. My counter signature is also there.
The said document contains my counter signature.
इसका सेकंड कॉपी
the second copy of the said document.
पहले पेज की तरह सेकंड कॉपी भी इंडोज करके
Like the first page of the document is endorsed.
इंडोज करके कस्टम्स
आप पूरा बोल दीजिए, फिर हम उसको डिक्टेशन देंगे। पूरा बोल दीजिए।
कस्टम इंडोज करके सारे एक्सपोर्ट डॉक्यूमेंट के साथ हमको दिया, हम लोगों को दिया, हमको दिया।
Second page also endorsed by the custom office, and after verification all the formality, after completion of all the formalities, the same was handed over to me. This said document was handed over to me.
टू सब इसको नेगोशिएटिंग बैंक में सबमिट करने के लिए।
For the purpose of submitting before the negotiating bank.
With all the export documents.
Along with all the export documents.
अब नेगोशिएटिंग बैंक का काम है, नेगोशिएटिंग बैंक का ये काम है फॉरेन करेंसी रिमिटेंस हो जाने के बाद
बोलूं
उसका एक कॉलम है इसी फॉर्म में फॉर द ऑथराइजेशन डीलर्स यूज।
The said form contains one column under the heading
for authorized dealers used.
For authorized dealers used.
Used.
नहीं
हाँ यूज।
Yes.
उसमें जो फॉरेन करेंसी रेमिटेंस होता है उसका पूरा डिटेल्स।
In the said column, the details of the foreign currency
remitted by the importing country.
Remitted by the
importing country. उसको पूरा फिलअप करके फिर ये सेकंड कॉपी आरबीआई को नेगोशिएटिंग बैंक भेजता है।
After filling in that column, RBI sends a second copy.
RBI नहीं, नेगोशिएटिंग बैंक।
नेगोशिएटिंग बैंक।
नेगोशिएटिंग बैंक आरबीआई को भेजता है।
नो क्या लिखे मैडम बताइए।
গুছিয়ে সেন্টেন্স কিন্তু মানে দাঁড়াচ্ছে না কোনো।
After filing that column, it has been.
No, it is sent to the RBI by the negotiating bank. RBI by the negotiating bank.
After filling.
Already.
After
filling of that portion. Yes.
जब ये दोनों कॉपी आरबीआई के पास जब पहुंच जाता है और आरबीआई अपने हिसाब से इसको चेक करके इस मैटर क्लोज कर देता है।
When these two copies are sent to RBI and after checking these two documents properly, RBI closes the matter.
May I? Okay. Witness, you have just referred to one customs. Which country's customs have you referred to herein?
আপনি কাস্টমসের কথা বলেছেন, কোন কোম্পানির কাস্টমের কথা?
কোন কান্ট্রি কাস্টম?
কোন দেশের কাস্টমের কথা?
Indian customs.
I have told about Indian customs.
Now please have a look at the document appearing at page 2 and tell my lord whose signature appeared at the top and whose signature appears at the bottom of the said page.
2 নম্বর পাতার উপরে এবং নিচে কার কার সই আপনি দেখতে পাচ্ছেন, মাই লর্ডকে বলুন।
मिडिल में जो है वो इंडियन कस्टम्स का।
In the middle portion, the signature is of
stamp and signature
of Indian customs person, and the stamp of Indian customs is also appeared there. নিচেরটা
CHA agent, custom house agent.
And the signature appearing on the below portion of the document is the signature of CHA custom house agent of custom house agent.
CHA Wittenberg custom house agent.
Now please have a look at the next page and tell my lord who are the signatories of the two signatures appearing therein.
পরের পাতায় যে দুটো সই আপনি দেখতে পাচ্ছেন সেগুলো কাদের সই মাই লর্ডকে বলুন।
एक सिग्नेचर है, ऊपर में पहला सिग्नेचर है सुपरिंटेंडेंट ऑफ इंडियन कस्टम्स।
The first signature appearing on the said document is of the superintendent of Indian custom. পরেরটা
सेकंड सिग्नेचर है इंस्पेक्टर ऑफ द इंडियन कस्टम्स।
The second signature is of the inspector of Indian customs.
जिस इसके प्रेजेंस में माल एक्सपोर्ट हुआ।
In whose presence the materials were exported.
उसके नीचे मेरा सिग्नेचर।
And below the signature of the inspector there appears my signature.
Do you know the signatures of all these people that you have just mentioned?
আপনি যাদের সইয়ের কথা এক্ষুনি বললেন তাদের সই কি আপনি জানেন বা চেনেন?
জি।
Yes.
Now, are you in possession of the originals of these documents?
এই ডকুমেন্টগুলোর অরিজিনাল কি আপনার কাছে আছে?
ना हमारे पास नहीं है।
No, I do not have the originals of this of
ये
the said documents.
ये नेगोशिएटिंग बैंक को सबमिट किया हुआ है, क्या हुआ था?
All the said documents were submitted to the negotiating bank
for negotiation of the documents,
for negotiation of the documents.
Public purchase of the documents.
Are you aware as to how many copies of the originals of these documents are prepared?
এই ডকুমেন্টের কতগুলো অরিজিনাল কপি তৈরি করা হয়েছিল বলতে পারবেন? 9 copies were made. 9 original copies were made.
Why are they 9 in number and not more or less?
ঠিক 9 কেন সংখ্যাটা বেশি বা কম নয় কেন?
क्योंकि ये नो के अगेंस्ट में ये नो जीआर के अगेंस्ट में ही पेमेंट
बोलिए
नहीं आया है।
Because the payment against GR9 has not been received yet.
9
GRs.
9 GRs have not been received yet.
Now I'm showing you one bunch of documents.
Just a minute. What is the meaning of GR?
GR का मतलब क्या है?
जीआर का मतलब हम नहीं जानते सर, इसमें जीआर लिखा हुआ है इसलिए हम बोल रहे हैं।
I do not know the full form of GR or meaning of GR. I refer to GR as it is written on the said.
It's appearing in the said documents.
Please tell my lord that in the instant proceeding, how many letters of credits are involved, or for which you have not received payment?
এই ব্যাপারটায় কতগুলো লেটার অফ ক্রেডিট ইনভলভ আছে যেগুলোতে আপনি পেমেন্ট এখনো পাননি?
more or less 9.
Now I'm showing you a set of documents. Please tell my lord whether these are the exact copies of the documents that I've just referred to.
এক্ষুনি যে ডকুমেন্টটা উনি রেফার করলেন এগুলো কি তার মানে এক্সাক্ট কপি দেখে বলুন।
The copies of documents I've referred to at pages 2 to 19.
जी वही डॉक्यूमेंट्स है।
Yes, these are the same document.
My lord, I would like to tender this document. These are the original copies of the documents, my lord. Your lordship will kindly have a look.
This is Xerox copy.
Yes, my lord. He has said that the originals have.
I am objecting to this mode of proof, your lordship. Mode of proof as well as the documents.
What
This
is the
cannot
last
be-
exhibit here? Double X.
Your lordship, these ought to be marked for identification because the mode of proof is not complete. May I, in that case,
Have you? Where is the denial and admission denial of the document?
They have not taken inspection, and he can't have
your
originals.
lordship, the issue is this: whether I take the inspection or not in this case is immaterial, since all the documents, whether the documents in the judge's brief of documents or whether the ones which have been exhibited, all are photocopies. None of them is original. And as per the Evidence Act, your lordship, and they are not saying that those lie with me. Had it been so, then even a notice to produce would have
possibly served the purpose. But it's not the case, Your Lordship. Unless the take the appropriate step, they cannot get it marked as an exhibit. May I in that case refer to the provision, Your Lordship?
No, first of all, my lord, they have not taken inspection of these documents. They have refused. And now, my lord, they are coming up, and my lord, it has been the witness's case that they get copies because the RBI cannot give originals of the documents to them. Yes, the original shown appears to be the power.
The person is in the room proof or of any person out of reach or not subject to.
Your Lordship kindly comes to section 65, Your Lordship.
Yes.
May I please? Cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or contents of a document in the following cases. A. When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved. Against whom the document is sought to be proved. I'll read out the entire A. Or of any person out of reach of or not subject to the process of the court or any person legally bound to produce it. And when after the notice mentioned in section 66, such person does not produce it. Now, Your Lordship, section 66 comes only into play if the witness would have made the witness step out, Your Lordship, for the moment, Your Lordship, because if the witness deposed before Your Lordship that those documents are lying with me, then in that case, because I am the LC issuing bank, Your Lordship, now the case is against me that I have not made payments against the negotiating documents, against the letter of credit which I have issued. So the documents which are sought to be proved are against me, Your Lordship. Now, Your Lordship, when the claim is against me, the documents sought to be proved are against me, and the witness has not deposed that those are lying with me. The witness has a while back deposed that the same is lying with his negotiating bank. With his negotiating bank, against whom the claim is not arising of the plaintiff. Hence, in that case, a notice to produce also does not suffice. There are appropriate steps, Your Lordship. Let my learned friends may take those steps. They cannot just circumvent those steps and try to get these exhibited.
If my learned friend has finished, my lord, may I have an opportunity?
Yes, anything further?
That's all, Your Lordship, because then only the question of proving a secondary evidence comes in. Had it been in my possession, because the witness has already admitted, not saying it is in my possession. And the witness also admitted that to the fact that he knows in whose possession it is.
Yes.
Yes. Well, first of all, as has been submitted by my learned friend, we are not saying for a second that these documents are in their possession. The witness has very specifically said that these documents are in the possession of the Reserve Bank of India, which was sent through Punjab National Bank, our negotiating bank. Mala, these documents only goes to show that the Indian customs have approved of the fact that the goods have crossed the border and has gone to Bangladesh. Malad, I know that it pinches their shoe quite a lot, inasmuch as, in spite of the importer having accepted the fact of having received the goods, their bank is not wanting to release the money for reasons best known to them. Malad, this is
my learned friend senior friend going into the merits.
It's because my lord has to understand as to what
Does
documents
not
are being given for.
This is a procedure which has to be adopted.
This document is in possession of RBI. My lord, this document has been signed by the customs, and my lord, the notice to produce to give them does not arise because it is not our case that it is in possession of the defendant number 4. So, my lord, under that circumstances, if your lordship kindly comes to 65A, the second part.
Yes.
May I read out from 65A from the beginning? When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, I'm not on that, I'm not. Or of any person out of reach of or not subject to the process of the court or of any person legally bound to produce it. And when after the notice mentioned in section 66, such person does not produce it. My lord, may I come back to this again? Reserve Bank of India is not subject to the process of the court. So, my lord, my humble submission would be, inasmuch as the specific case of the witnesses, the documents are in possession of Reserve Bank of India, which has not been denied by them. They do not even know as to whether it is a copy or whether it's an original. They have not taken the pains of inspection. Now, at this stage, my lord, they cannot come up and they cannot object.
No, the problem is that, see, you are. Can the witness go out?
Yes.
Because you have to prove that you are this all document, the GR form and all these things, you have submitted, custom has verified, no, custom has verified and sent to the negotiating bank, and negotiating bank after verification sent to the RBI. Correct. But the problem is that you wanted to prove the document that it has been up in the from the this document. You wanted that the materials has been reached, verified the customs and handed went to. So you mainly you wanted to produce. You wanted to prove that customs certificate that the materials has been reached to the Bangladesh boundary.
Yes, ma'am.
That is your question.
Yes.
So for the proving of that, so how this document you will prove?
There are other original documents in support of this, which shows that this is the
How the document you will prove?
My lord, with respect, your lordship has seen that these documents, the originals of these documents cannot be in the possession of my client.
Correct, no problem.
My lord, this provision is there that the RBI, it is in possession of RBI. It is in possession of RBI. That is the deposition that has been given, that my issuing bank, PNB, has given it to RBI. Now, my lord, RBI is not subject to the process of this honorable court in this proceeding, as a result of which, my lord, I come under 65A, if your lordship kindly, second part of it. So, under such circumstances,
there are original supports this GR form also.
my lord, under that provision, these documents will be covered, as a result of which secondary evidence of these documents can be allowed, inasmuch as they are in possession of RBI, who is not subject to the process of this honorable court.
Question of original does not. Here the question with regard to the how this document is to be admitted in evidence.
Yes, ma'am.
Correct. The question of admission. He is not the author.
No.
He is not the borrower of the custodian of the document.
He's a signatory.
He is a signatory.
Yes,
correct. He is a signatory.
Yes.
His signature is available here.
And he has identified the signature. It
Signature.
has been done. Yes.
Correct. This signature. So maximum is signature because his signature can be exhibited on a secondary document. His signature can be with regard to the custom signature. You have to take appropriate steps.
No, but with respect, my lord, under this provision, I put a question to myself. Would I?
C and D, any secondary evidence of documents that
My lord, would I be required to take that? With respect, once, my lord, it is no the
out of reach. Here you need not to prove that the document reached to the RBI. You need not to prove. You have to prove that this has been verified by the custom and sent it. And that's why unless the custom has verified, the document will not be given to you for submitting in the negotiating bank.
Yes.
That is the process.
Yes.
So the custom verified, given to you, you have submitted to the bank. So you have to prove, yes, custom has verified the materials, it reached to the boundary of the Bangladesh. So custom has verified. So what you have to prove? Not the document, you have to prove with regard to the customs signature. Yes, this is our signature. We have verified and we have put the seal. So what you will do? You understand?
Well, that portion with regard to that the goods have been verified and gone, that has already been proved before the learned commissioner. That
So whether,
those
if it
those
is proved by
those
which
documents-
evidence, which document,
then my lord, the commissioner's report is there.
which evidence? If it is proved, whether there is an other document was exhibited other than this. What document?
There-
একটু দিন আমাকে
Judge সাহেবের কাছে।
আমি বার করে দিচ্ছি বার করে দিচ্ছি
This is, my lord, only with regard to negating their new case of collusion between importer and exporter. My lord, here, what we are trying to establish before my lord is that there has not been any defalcation of funds done. There has not been any illegal activity. Our export has been recognized by the result.
No, so if you are telling that they have not taken any stand in the written statement, they put the cross-examination. At the time putting the cross-examination, you have made an objection. It has been recorded as an objection. If they have not,
with respect, my lord, not at the time of cross-examination. At the time of their examination and chief of their witness.
they cannot without the pleading. So the judgment.
That is exactly that.
And that cannot be that even in the written statement they cannot go beyond the pleading.
What they have said, I'll tell you, Your Lordship, what has happened. What they have said is that there has been a defalcation of fund and that they have taken up a proceeding.
Whether that is in the written statement.
Yes, that case they have made. But thereafter, in the course of their examination in chief, they have brought out a judgment in which they are relying upon an observation that the exporter and importer, they are in collusion with each other. That was not a part. As a result of which, my lord, in order to demolish that, we had to take out this application for additional evidence. And that was allowed.
ये कौन सा exhibit है देखो? ये exhibit कौन सा है? O/1 कौन सा exhibit है?
And there are original documents in support of all this.
এটা আমি এখনো প্রমাণ করিনি আমি কথা বলছি আরবিআই থ্রু দিয়ে এসছে
এটা আছে তো এখানে
হ্যাঁ এটাই তো অরিজিনালটা
আচ্ছা তোমরা
9 to 12
না
সেটা আগের কমিশন
হ্যাঁ আগের কোনটা দেখা হচ্ছে
কমিশন
Your Lordship, may I know which document is being relied upon by my learned senior friend, which has been adduced in evidence previously, Your Lordship? The document which my learned senior friend is relying upon, which has been exhibited previously, may my learned friend kindly indicate which document?
Exhibit O.
Exhibit O.
হ্যাঁ সব যেগুলো আছে সেগুলো আছে এটা ফর এক্সাম্পল বিজনেস শো একটা হচ্ছে এখন এটা প্রমাণ করি ওটার অরিজিনাল
Yeah. Yes, earlier also you are not objected for that.
Your Lordship, may I have a look at the document, please? May I have a look at the document?
Kindly sees
the new documents which will be shown.
Your Lordship, kindly.
All originals in support of this.
Lordship, kindly envisages the situation. I write the.
Okay, you object. I am objecting with objection.
Your Lordship kindly records that the mode of proof it's objected. Your
They have neither they are going to find
Your Lordship,
affidavit of admission or denial, nor
Your Lordship
take
may
inspection at the
Your
time
Lordship,
of,
let it be let the objection go through as the mode of proof has been objected to.
Only to delay.
Yes. Let my learned senior friend continue, but let the objection go in that I am objecting to the mode of proof at this juncture.
Documents marked as exhibit. YY.
Your
YY with objection. With objection. Within bracket as क्या
Mode of proof.
As the plaintiff has
Mode
not.
of proof and as admissibility both, Your Lordship.
What admissibility?
Your Lordship, since we have to argue later on only.
So that is objection.
Yes, Your
With
Lordship.
Objection.
Yes, both on both
Actually,
counts.
Your Lordship will also be pleased to observe that no inspection was taken by them.
With objection.
That is there on record.
Next. Yes.
Yes, may I proceed?
With Your Lordship, may the mode of proof also go down. Your Lordship, else it won't be recognized at a later stage. Your Lordship kindly does not do this.
Continue.
Your Lordship, let the mode of proof go down.
You are not inspected.
Your Lordship,
have you inspected the document?
Your Lordship, if they are not providing the originals for inspection, there is no point in
Where is the plea? They have not produced the original. Where is the pleading?
Your Lordship,
You have given the letter that they have not produced the original.
They refused to take inspection. That is recorded.
Your Lordship,
The
now
court
at
record
the
there. My order is there. You refuse to take the inspection. Yes, next.
Witness, I'm showing you a document, a copy of which appears at page 22 of volume 1 of the additional judge's brief of documents. Please tell my lord, what is this document about?
Which number, sir? 22.
Page 22 of the...
আপনি এটা দেখুন না ডকুমেন্টটা দেখুন এবং মাই লর্ডকে বলুন এটা কি ডকুমেন্টটা কি ব্যাপারে
পরে বলবো 22 enlistments
सर ये रिजर्व बैंक ऑफ इंडिया से हमको लेटर दिया गया.
दिस इज अ लेटर
आप कंप्लीट कर दीजिए अपना सेंटेंस पूरा कंप्लीट कर दीजिए. हाँ,
रिजर्व बैंक ऑफ इंडिया से हमको लेटर दिया गया कि ये 9 GR के अगेंस्ट में पेमेंट नहीं आया है. इसके लिए क्या आपने एक्शन लिया?
These are the letter issued by the Reserve Bank of India making query that the payment has not been made and not been received with respect of the GR.
9 GRs.
With respect of 9 GRs and what action has been taken by the plaintiff.
इसमें एक GR मेरे ख्याल से लोग लिखना भूल गए हैं बाय मिस्टेक. 8 इसमें अपेयर है, एक इसमें मेंशन किया हुआ है.
In this document only details of 8 GRs have been given and 1 GR detail is not given. I think it is by mistake.
लेकिन दूसरे डॉक्यूमेंट्स में ये कवर कर रहा है.
In the other documents, 9 GRs have been covered. Next.
Now, if you're finished, please tell me. Okay. Now, please have a look at documents appearing at pages 23 and 24 and tell my lord, what are these documents about?
23 and 24 দেখুন এবং মাই লর্ডকে বলুন যে ডকুমেন্টটা কি ব্যাপারে. 23 and 24 পেজ নাম্বার 23 পরেরটা 24.
ये उसी लेटर का ये एनेक्चर है सर.
This is the annexure of the said letter.
उसमें पूरा GR का डिटेल्स दिया हुआ है.
In the said document, the total GR details have been depicted or given.
Are the documents appearing at pages 2 to 19 are in connection with the GRs mentioned at pages 23 and 24?
2 থেকে 19 পাতায় যে ডকুমেন্টগুলো আছে সেগুলো কি 23 এবং 24 পাতায় যে জিআরটা মেনশন আছে তার সঙ্গে জড়িত সম্পর্কিত?
हाँ, उसमें सिर्फ एक तो GR नहीं है.
Yes, but 1 GR is missing. But there
बाय मिस्टेक उन लोगों ने RBI वालों ने लिखना भूल गया बाय मिस्टेक.
maybe by mistake RBI to write it down. Mention it করো.
Is this the original of the letter that you have received from the Reserve Bank of India?
এটা কি সেই অরিজিনাল লেটারটা যেটা আপনি রিজার্ভ ব্যাংক অফ ইন্ডিয়া থেকে পেয়েছেন?
हाँ जी, ओरिजिनल है ये.
Yes, this is the original.
Are the annexures to this letter appearing at pages 23 and 24 have also been sent by Reserve Bank of India to you?
এই ডকুমেন্টের সাথে যে অ্যানেক্সচার দুটো আছে 23 এবং 24 পাতায় যেটা দেখানো হয়েছে সেই দুটোও কি রিজার্ভ ব্যাংকের দ্বারা আপনাকে পাঠানো হয়েছিল?
জি জি.
Yes.
My lord, this is the original. I'd like to tender these documents and all three are to be marked as exhibit.
Maybe with objection.
You the
কিসের objection এবার?
What is the objection? Original.
Objection is the original. He is the recipient of the document. That's the original.
It is
And
addressed to him in the
then
original.
direct to him.
In the order, addressed to him, addressed to the plaintiff.
Rejecting is raising objections.
Your
Exhibit.
Lordship, this is not addressed to the plaintiff.
Huh?
The name is written,
Huh.
but it's not addressed to the plaintiff.
Can you see?
আগে পাতাটা দেখ না না দেখে কেন বলছিস কোর্টেতে
Yes, Mrs.
Page
Danish
20.
expert.
Yes, Your Lordship.
Mrs. Danish expert,
Page
48 Jagaria Street, 48. So, what, whose name?
Yes.
Whose name?
Wait.
Exhibit YY. ZZ.
collective
Collectively.
No.
पहले वाला भी हुआ ना, कलेक्टिवली किया था ना, अभी कलेक्टिवली आएगा।
ওটা লেখা হয়নি কিন্তু
ওয়াই ওয়াই হচ্ছে না
अभी कलेक्टिवली आए और दे दो YY कलेक्टिवली कर दो।
Please have a look at exhibit ZZ collectively and tell my lord, what steps have you taken to realize the foreign exchange?
ফরেন এক্সচেঞ্জকে রিয়ালাইজ করতে আপনি কি কি স্টেপ নিয়েছিলেন এটা দেখে মাইলটকে বলুন।
सर वेरियस फॉरम में हमने लेटर दिया।
I have submitted letters to various forums,
including RBI, Ministry of Bangladesh, Indian High Commission at Bangladesh, और RBI के गवर्नर से पर्सनली जाके हमने मिला। RBI के गवर्नर से
I met personally the governor of RBI
in Bombay.
in Bombay. I went and met the governor of RBI at Bombay.
और मैंने वहां पे उनसे मांग किया इस बैंक को रिस्ट्रिक्टेड वे में डाला जाए।
And there I demanded that this bank should be listed as restricted
bank.
The governor of RBI ने हमको कहा कि ये तो मुमकिन नहीं है।
The government of RBI told me that this is not possible. This was not possible.
और उन्होंने एडवाइज किया कि आप कोर्ट में मूव कीजिए।
And he advised me to file a litigation in the court.
Before the court, move before the court. Yes,
Sir.
next.
Sir.
Finished?
Yes, sir.
You can give back. So, did you apply for extension of the time to get refund of the foreign exchange?
Foreign exchange থেকে রিফান্ড পাওয়ার জন্য আপনি কোনো টাইম এক্সটেনশন বাড়িয়েছিলেন?
जी सर, आफ्टर 6 month
Yes, after 6 months बोलूं।
अगर पेमेंट फॉरेन करेंसी रेमिटेंस नहीं होता है तो आरबीआई का गाइडलाइन है इसको एक्सटेंशन माने टाइम एक्सटेंशन कराने के लिए।
Yes, if after 6 months the foreign remittance has not been done, there is a guideline in RBI for giving an extension of time.
For praying for extension of time.
For praying for extension of time.
Through their ETX forum.
Through their ETX.
Accordingly, हम time to time ETX फॉर्म को फिलअप करके हमने टाइम एक्सटेंशन लिया है।
According to that, from time to time, I have filled in the ETX form and prayed for time.
Prayed for extension of time.
Prayed for the extension.
And we are getting the extension from the concerned bank.
And we got the extension from the concerned bank.
Now, witness. Witness, I'm showing you documents copies of which appear at pages 84 to 133 of volume 1 of the additional judge's brief of document. Please have a look at these documents and tell my lord what these documents are about.
স্যার এই ডকুমেন্টগুলো দেখুন এবং মাই লর্ডকে বলুন এগুলো কি ব্যাপারে।
Please go slowly and dot sentences.
This document appearing at
pages 84 to 133.
सर ये
My lord.
सर ये
My lord.
माय लॉर्ड ये रिजर्व बैंक ऑफ इंडिया का लेटर है
बोलूं 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 सर,
जो कि पंजाब नेशनल बैंक के नाम में इशू किया हुआ है। इसमें जो 9 GR का जो पेमेंट नहीं हुआ है उसका पूरा डिटेल्स है।
This is a letter which was written by RBI to
Punjab
National Bank. In this letter, the 9 GRs against which the payments were not made has been mentioned. बोलूं सर,
हमको कॉपी इंडोर्स भी किया है उसने, आरबीआई ने कॉपी इंडोर्स किया है।
I have been endorsed a copy but by the RBI. I have been endorsed a copy of this letter.
the copy of the said document has been endorsed to me.
और इसमें वेरियस कॉरेस्पॉन्डेंस है बाय द हमारे नेगोशिएटिंग बैंक पंजाब नेशनल बैंक से।
In the said documents, there are various correspondences by our negotiating bank, that is Punjab National Bank.
आरबीआई को बोला गया है।
In the said document, RBI is told
पेमेंट नहीं होने का पूरा डिटेल्स।
RBI told about the details of the non making of the payment
against
receipt
of the payment
against 9 GRs
against the 9 GRs.
में एक लेटर बफेडा को भी लिखा है।
There is a letter in the bunch of the document which was written to
Bafeda, Chairman Bafeda,
to the chairman of Bafeda, BAFEDA,
Eastern Commercial Complex. ककराइल ढाका बांग्लादेश। कोई भी पेमेंट नहीं मिलने का पूरा डिटेल्स दिया हुआ है। और
in this letter also there is the description of non receiving of the payment and
to recover the payment with this इस माने बफेडा के थ्रू भी रिक्वेस्ट किया गया है पेमेंट ये करने के लिए, रिलीज करने के लिए।
and through Bafeda
also requested for release of payment. Yes.
एक लेटर हमने 10 जुलाई 2007 को,
a letter dated 10 July 2007
वो हमने पंजाब नेशनल बैंक को
was written by me to Punjab National Bank
regarding non-payment of against 9 GRs.
Was written by me to Punjab National Bank regarding the non-payment against the 9 GRs. There is a letter on the bunch করা প্রথমে হ্যাঁ ডকুমেন্টের মধ্যে একটা চিঠি এটাও আছে
उस लेटर की कॉपी गवर्नर ऑफ गवर्नर इंडो बांग्लादेश ज्वाइंट बिजनेस काउंसिल को भी दिया गया है
A copy of the said letter was also sent to the governor, Indo-Bangladesh Joint Business Council,
banking subgroup,
Indo-Bangladesh Joint Business Council, banking subgroup. A copy of the letter was also sent to UMUK.
उस लेटर का सेम कॉपी गवर्नर ऑफ आरबीआई
The same copy was also sent to the governor of RBI,
सेंट्रल ऑफिस बिल्डिंग
Central Office Building,
शहीद भगत सिंह रोड मुंबई
Shahid Bhagat Singh Road, Mumbai.
लेटर कॉपी मिस्टर गोपालन एडिशनल सेक्रेटरी एंड चेयरमैन
Another copy of the said letter was sent to Mr. R. Gopalan, Additional Secretary and Chairman. Chairman, Grievance Redressal Committee, Ministry.
Ministry of Commerce and Industry,
Ministry of Commerce and Industry,
Department of Commerce,
Department of Commerce,
Udyog Bhavan,
Udyog Bhavan,
New Delhi.
New Delhi.
उस लेटर की कॉपी गवर्नर ऑफ बांग्लादेश
A copy of the said letter was also sent to the governor of Bangladesh Bank, Bangladesh.
कॉपी का लेटर उस लेटर का कॉपी
Copy of the letter was also sent to
Mr. P. Chakravarti,
Mr. P. Chakraborty,
the High Commission of India,
the High Commission of India,
Dhaka,
Dhaka,
house number 2,
road number
142,
road number 142,
Gulshan 1,
Dhaka,
Bangladesh.
Dhaka, Bangladesh.
I put the next question. You finished? All we have moved. If you have left anything, please tell.
पंजाब नेशनल बैंक ने एक लेटर लिखा.
Letter was written by the Punjab National Bank.
November 1.
I've given them in a set, so there are some.
The letter is dated November 1, 2007. 70 complete, sir.
Regarding non-payment of the export documents against 9 GRs.
Regarding the non-payment of export documents of against the 9 GRs.
Export documents?
I already said that.
इस मैटर को बिजनेस स्टैंडर्ड न्यूज़पेपर बिजनेस स्टैंडर्ड हमारा फेडरेशन ऑफ इंडियन एक्सपोर्ट ऑर्गेनाइजेशन पीओ न्यूज़पेपर में भी दिया 20 अप्रैल 2007 को.
This matter was also published in a newspaper, namely Business Standard. PO ব্যাপারটা একটু বলুন আরেকবার.
Federation of Indian Export Organization.
On April 20, 2007.
By
Federation of Indian Export Organization, bracket FIEO, FIO.
इसी सिलसिले में फेडरेशन ऑफ इंडियन एक्सपोर्ट
regarding this matter, FIO
पीओ ने द चेयरमैन एंटी करप्शन कस्टम कमीशन एंटी करप्शन कमीशन को भी दिया, एंटी करप्शन कमीशन बांग्लादेश को भी दिया।
PO also issued a letter to the chairman anti-corruption commission Dhaka, Bangladesh. PO also issued a letter to
उसमें बहुत सारे लोगों का पेमेंट था, उसमें मेरा भी है।
उसमें बोल
along with the annexure board.
Along with the annexure, along with the said letter, there is an annexure which depicts that many payments have been due, and among the due payments, there is also a due payment of mine. It also reflects the due payment of mine.
उसके बाद सब ETX का पूरा सेट है। ETX मैंने जो एक्सटेंशन के लिए हमने एप्लीकेशन किया है उसका पूरा सेट है।
After that, the bunch contains the total ETX set
for extension of time limit,
to which I applied for the extension of the time limit, by which
ETX application.
Extension.
Extension application. Yes. Yes. Next. Witness, have a look at pages 114. I'll just mention the pages at the same go, and you can just 114, 117, 120, 123, 126, 129, and 132. And tell my lord whose signature appears on the said documents.
আচ্ছা একটা একটা করে
আমি বলবো, shall I tell them?
না না লিখে দিয়েছি স্যার। 114, 117, 120, 123, 126, 129 এবং 132 নাম্বার পাতাটা দেখুন এবং বলুন যে কার সই আপনি দেখতে পাচ্ছেন। মাই লর্ডকে বলুন একটা একটা করে। 114 স্যার প্রথমে।
114 में माय लॉर्ड हमारा सिग्नेचर है।
Page number 114
Number 114 at the bottom
contains my signature.
there appears my signature. এরপর 117 স্যার।
माय लॉर्ड इसमें मेरा सिग्नेचर है।
This is also my signature. 120
अब सब में देख ले, सब में आपका सिग्नेचर है।
सब में उनका है।
120 अपना सही
जी मेरा सिग्नेचर है माय लॉर्ड।
all papers contains my signature. Carry then
123
मेरा सिग्नेचर है सर 123।
26
माय लॉर्ड
26
माय लॉर्ड मेरा सिग्नेचर है 126।
ठीक है, ठीक।
29
माय लॉर्ड मेरा सिग्नेचर है
32
माय लॉर्ड मेरा सिग्नेचर।
all the mentioned pages contains my signature.
Yes.
Are the documents appearing at '84 to 133 been received by you from Reserve Bank of India?
এই 84 থেকে 133 পর্যন্ত যে ডকুমেন্ট সেটা কি আপনার দ্বারা আরবিআই থেকে, আপনি কি আরবিআই থেকে পেয়েছেন এই ডকুমেন্টটা স্যার? এই সেটটা এটা কি আপনি আরবিআই এর তরফ থেকে পেয়েছেন?
ये लेटर हम आरबीआई से हमको मिला।
The first letter appearing on the state document has been received by me from RBI.
What about the document appearing at page 86?
86 এর যে ডকুমেন্টটা পেয়েছেন সেটা, ওটা কি আরবিআই থেকে পেয়েছেন? এখানে দেখুন স্যার 86।
No, the originals. Show him the originals. I'm showing him the original.
86 कंपेयर कर लो उससे।
এই ডকুমেন্টটা এখানে দেখুন আপনি এই ডকুমেন্টটা। এটা কি আপনি আরবিআই থেকে পেয়েছেন?
जी आरबीआई से हमको मिला है।
Yes, this The document appearing on page number 86 has also been received by me from RBI.
So are these original documents?
এগুলো কি original document?
The original documents.
Yes, these are the original documents.
Are the rest of the documents and the correspondence annexed to this bunch also originals received by you?
বাকি ডকুমেন্ট এবং চিঠিগুলো যেগুলো এই বাঞ্চটার মধ্যে আছে সেগুলো কি সব অরিজিনাল?
Original, sir.
Yes, these are all original documents.
My lord, may I tender this bunch appearing at pages 84 to 133 and may they be exhibited collectively?
इससे पहले था वो ये ना इससे पहले जो पढ़ा था ना, these are the same documents earlier which he has referred. Prior to this, these are the document. Earlier he referred so many documents. Page 1.
Why documents?
These are the same documents.
Yes, my in one bunch I have given so that he's explained
Exhibit.
everything.
AAA collectively.
The problem arises, my lord, when the other side, they don't raise any dispute at the proper time. We take it that they're admitting it. So now at the time of deposition, examination, when all these objections come, then my lord, our whole mental frame gets changed.
No.
Because there is no affidavit of admission and denial. There is no inspection. There is no denial whatsoever with regard to
That's why I in my court I made a practice. I will go by the affidavit of admission and
Yes,
denial.
my lord.
Because the time is also shortcut.
Yes.
If they denied, yes, denied with regard to the admissibility of the document or contents of the
Yes.
document or signature of the document, then the court
So we are also
it can
ready.
record.
The other side is also ready as to what is the scope
What
of
is-
the examination.
That is the problem.
They're springing a surprise upon us. They're
Not
going against
The
character.
only difficulty arises because my learned advocate on record is not present. Because I am not in a position to get the instructions.
You're going against the principles of Calipiat's case. You're springing a
Then
surprise.
it ought to be.
You're-
Then it
you're
ought to be
springing a-
adjourned today.
You're bringing a surprise. That is up to my lord. I cannot quite say about that. 3rd June. 52. Now-
Mr. Datta will not come for the adjournment before this court.
Yes, my lord. That
I don't.
He's putting it on me. He's putting it on me.
Because I generally don't prefer seeking adjournments unnecessarily.
That is exactly what I say. You are putting it on me. So that I will request pray before my lord. To 72.
73.
Okay. Witness, I'm showing you a bunch of documents, copies of which appear at pages 50 to 73 of volume 1 of the additional judge's brief of documents. Please tell my lord one by one as to what these documents are about.
এই ডকুমেন্টগুলো দেখুন এবং এক এক করে মাইলটকে বলুন যে এই ডকুমেন্টগুলো কি ব্যাপারে।
3 बजे आना तो नहीं होगा। अच्छा उस दिन ना एक कौन ही था जिसमें घूस लोग वो करेक्शन के लिए मांगता था।
पहला लेटर है रिजर्व बैंक ऑफ इंडिया ने
ओझा।
The first
उसमें
letter
जो करेक्शन
appearing
का
on the
वाला
page
वो
bunch
क्या
of
वापस कर दिया?
is from RBI.
वही कहा मेरे को दे दो कर दे।
पंजाब नेशनल बैंक
First letter appearing at the
ডকুমেন্টের বাঞ্চটা দিয়েছে। The first letter of the bunch is a letter from Reserve Bank of India to the manager of Punjab National Bank. তারিখটা বলবেন। লেটারের তারিখ বলবেন স্যার।
लेटर dated 3rd June 2008.
The letter is dated 3rd June 2008.
कॉपी इंडोर्स टू हमको कॉपी इंडोर्स किया क्या है?
A copy of this letter has been also endorsed to me.
मैं ETX एक्सटेंशन के लिए एक्सटेंशन ऑफ टाइम लिमिट के लिए is the 2008 तक के लिए एक्सटेंशन ऑफ टाइम लिमिट इसमें सेंक्शन किया गया है इसलिए
by the said letter an extension of time up to 30th October 2008 was given against my ETX application को दो
Against me, not say ETX against my extension application.
पंजाब नेशनल बैंक रिजर्व बैंक को बोलो लेटर लिखा है 23 मई 2008 को
This is the letter issued by the Punjab National Bank to the Reserve Bank of India on
23rd March 2008 my lord
regarding ETX application
regarding ETX application
regarding extension application.
for extension of time
account Danish Export Corporation
account Danish Export Corporation. The next document is required.
पंद्रह मई 2008 को
बोलूं
के बाजुरिया एडवोकेट उस वक्त हमारे कौंसल एडवोकेट थे उन्होंने केस का क्या स्टेटस है वो लिख के हमको दिया था
on 15th May 2008 our then counsel Mr. A. Bajoria gave us a written status of the case
to submit RBI
to submit RBI
for submission of RBI.
This is the third document.
Your lordship has to rise, my lord. We understand. If your lordship so wants, we can come some other day.
Let it be completed 359 will time.
As your lordship, whatever is convenient for my lord.
रिजर्व बैंक ऑफ इंडिया ने 19 मई 2008 को
on 19th May 2008 Reserve Bank of India
लेटर लिखा पंजाब नेशनल बैंक को
given a letter to Punjab National Bank
subject ETX application
regarding the ETX application
extension of time
for extension of time period
account Danish
on account of Messrs. Danish Export Corporation. Develop document.
April 29, 2008.
On 29th April 2008.
Punjab National Bank.
National Bank.
General Manager RBI को
wrote a letter to the General Manager of RBI
regarding extension of time limit.
Regarding the extension of time limit.
You give a gist of you don't read out the entire documents. We can read that. Please just give a gist.
সবটা একেবারে দেখে নিন দেখে বলুন যে কি জিনিসগুলো জাস্ট একটা সারমর্ম বলুন যে কি এগুলো আপনি একবার দেখে নিন প্রত্যেকটা
Because if you're reading out, the documents will speak for themselves.
Mr. Federation of Indian Export Organization.
Federation of
Indian Export Organization
एक लेटर लिखा है
has also issued a letter
dated
9 April
2008. There is also a letter issued by it dated
Additional Secretary, Ministry of Commerce and Industry, Department of Commerce, Government of India, उद्योग भवन ने भी लेटर लिखा,
has also issued a letter.
क्या होगा?
regarding the such subject.
Regarding the above mentioned subject को
presentation
Dated
तो नहीं है
2nd April 2008.
Dated 2nd April 2008.
इसलिए फिक्स है. अच्छा वही बना.
उसके बाद जो है सारा ETS extension application for permission of ETS extension.
After that, the bunch of document contains the application for permission to extend the period for realization of export profits.
Are these all original documents?
Yes, these are original documents.
I'm tendering this document, let them be marked as. They're all originals.
Exhibit triple B collectively.
Pages 50 to 73.
To be mentioned.
Pages 50 to 73.
Okay, stop here.
I'm deeply obliged, my lord. My lord, we have to come back. My lord, we have
take your इनको दे. Plaintiff witness is present. Examination in chief on recall resumed. During his examination on recall, documents were marked as exhibit YY2, YYTO2, TO2, triple B. Due to paucity of time, examination chief on recall could not be completed. Accordingly, chief is deferred. Let the matter appear on
December. We lose track of everything.
November में कोई देख. Central 30 है. 12th November at
2 p.m. my lord.
12:30.
12:30. And my lord, your lordship will be pleased to record that additional judges brief of document in 2 volumes have been filed.
The plaintiff has filed additional judges brief of document in 2 volumes after serving the copy to the land counsel for the defendant. Let the same be copied.
ওটা পেয়েছি সামনে খুলে নিয়ে বসে তুমি
Deeply obliged.